me begin or do you want to begin?
I can begin if you want, Senator.
Thank you.
Are you going on the other meeting with DCF?
I'm going on the meeting. I've got to vote in executive norms.
Okay, all right. Good morning, everyone. I'm representing Kathy Abercrombie, the co-chair of the Human Services Committee. I'd like to welcome you to our public hearing today, Tuesday, March 8th. Thank you all for being here today. And with that, any opening comments from Senator Moore?
I just want to say good morning, and I hope everybody's well. I know we had a lot of wind damage in parts of the state, so I hope you're all safe. Thank you, Representative Abercrombie.
Representative Case?
All good. Just so we know, we got 3 public hearings at the same time, so I'll try to bounce around the best I can.
Yeah, I think everybody's in the same boat with that. Thank you, Representative Case. And Senator Berthel.
Good morning, Madam Chair, and I would echo what Senator Moore spoke to. We did have quite a severe line of storms roll through Western Connecticut yesterday. Pretty impressive for March, but I also have a couple of conflicts overlaying this meeting as well, so I'll be bouncing around. But good morning, and let's get to work.
Good morning, Senator. Senator, just so you know, you're on the screen twice, and I'm not a techie, so I don't know how that happens, but I just wanted you to be aware.
All right, you know what? Maybe I'll leave and come back, so I'm only on there once.
Okay, whatever.
One of me is enough for sure.
Okay.
Thank you, ma'am.
Whatever works for you. Thank you, everyone, and thank you for being here. And with that, we will get started. First up is our Commissioner of DSS, Commissioner Gifford. Good morning, Commissioner. Thank you for being here.
Good morning, Representative Abercrombie and Senator Moore, Senator Berthel and Representative Case, and members of the Human Services Committee. I'm Deidre Gifford, Commissioner of the Department of Social Services. I am joined by members of my team from DSS who are here to provide subject matter expertise. We have a large number of bills that we're testifying on, representatives, so I'm going to do my best imitation of speed talking. But there are a couple of key points that I'd like to highlight. And I want to thank the members of the committee for considering a number of these really important proposals. Representative, would you like me to pause and take questions after each bill, or you want me to run through similar to how we did it last week?
I think it's easier if you run through all of them, ma'am, first, and then I know that legislators will make notes next to them, and then we'll come back to them.
Okay, very good.
Thank you.
You're welcome. Beginning with SB 191, an act concerning federally qualified health center payments and the provision of non-emergency dental services. This legislation contains 2 proposals. The first is somewhat of a technical proposal in existing legislation that talks about a cost-based reimbursement model. Since the department has gone to a so-called alternative payment model with FQHCs a number of years ago, we propose deleting outdated language in section 17B 245B to remove that outdated language. The second part of the bill speaks to the provision of non-emergency dental services. We are proposing language that delineates that non-emergency periodic dental services should be included whenever possible in a single periodic dental visit, as opposed to multiple visits spread over time, unless there's a medical reason, a documented medical reason to do such visits separately. This proposal is as a result of a settlement with an FQHC regarding allegations of overbilling the Medicaid program for certain dental services that were quote unquote unbundled over a period of visits rather than being provided in a single visit, such things as x-rays, fluoride application, cleaning, examination, et cetera. So this proposal would require that those be provided in a single visit absent medical necessity. I would note for the committee that a number of other states have proposed similar language, including California, Florida, Oregon, New York, Pennsylvania, and Louisiana that all have such similar limitations. Moving on to SB 192, an act concerning employment services assessment interviews and sanctions for temporary family assistance beneficiaries who fail to comply with requirements. Again, this contains two proposals that would help us to streamline the application process for temporary family assistance and would also reduce some punitive penalties for noncompliance. Many advocates have sought to streamline the eligibility process, and we've received a number of questions from this committee about our enrollment in TFA. To streamline the process to implement policies that are less punitive and more supportive of low-income families. Specifically, with respect to a TFA application right now, an applicant is required to schedule an employment services assessment within 10 days of the application date. And if they fail to schedule such an employment services assessment, it can result in a denial of their application. What we are proposing is to change that to within 10 days of the initial interview, so that there's a little bit additional time for the applicant to complete the required employment assessment. So the 10-day clock for scheduling that would not begin to run until the initial application interview is completed. The second proposal is has to do with when a family member fails to comply with the employment services requirement. And what we are proposing is to modify the penalty for such a family in the event that the employment services requirement is not completed. Currently, the penalty is a percentage of the total benefit to the entire family, and we are proposing to modify that only to address the individual who's out of compliance. We think this would preserve the benefit for the individuals in the household who are not out of compliance with the requirement, and allow those families to keep a larger percentage of the benefit. Happy to answer any questions on those two proposals that we think will significantly improve our process for TFA applications. On to SB 193, an act authorizing DSS eligibility workers to administer oaths. Again, this has to do with streamlining and making more convenient our TFA application process. Right now, federal and state law require that the mother of a child applying for TFA establish the parentage of the child if parentage has not previously been established. That parentage is required through the execution or acknowledgement of parentage or an affirmation of parentage through an oath. The acknowledgement right now must be accompanied by an oral recitation of the rights and responsibilities and must be notarized or witnessed. What SB 193 simply proposes is that we authorize our DSS eligibility workers or supervisors to administer the oath in connection with taking the affirmation or acknowledgement. We are finding that we have an insufficient number of notaries public in our regional offices and an insufficient number of child support services who are currently those authorized to administer the oath. And so by expanding the pool of workers in our offices who can administer the oath, it will make it easier for these families to complete their applications. SB 194, an act authorizing the Department of Social Services to contract with other states. This would simply extend to the Department of Social Services the authority that already exists for the Department of Public Health to enter into contracts with other states. We are not looking to change in any way the procurement process, but merely identify that if another state entity were to be the successful bidder of a procurement process, that we would not be prohibited from entering into a contract with another state entity. This has arisen most recently when DSS wished to procure the services of an academic institution in another state. Such services were not available through Connecticut academic institution, and we were unable to do so. And it actually limited the department's ability to execute some or all of the necessary services in that instance. So again, I would emphasize that this already exists for the Department of Public Health, and we're merely looking to extend that to DSS. SB 199 is an act concerning the opening or setting aside of a parentage judgment. This bill would create a standard set of rules for when a judgment of paternity may be opened and set aside in favor of establishing a new judgment of paternity. The proposal would require the courts to apply the same standard in situations where parentage was established by the court as it applies when parentage was established by acknowledgement of parentage. The court should take into consideration the best interests of the child before deciding whether to set aside the judgment. This analysis is not only consistent with the Connecticut Parentage Act, but also has been previously followed in many Superior Court decisions. So this bill proposes to codify what is both consistent with the Connecticut Parentage Act and usual standard practice based on court decisions. SB 281 is an act concerning penalties for unauthorized use of rate increases earmarked for staff wage enhancements at nursing home facilities. As many of you know, from time to time, the legislature has authorized specific rate increases for the nursing home industry that were earmarked for wage increases for staff. Also, from time to time, the department has been notified of particular facilities that have not, in a timely manner, passed those wage increases on to the staff. So the department adjusts the rates paid to the facilities. The facilities have not turned around and used those funds for the designated purpose. Under the current framework, the department may recoup the amount of funds that were provided to the facility for the wage increases. But there is no capacity for the department to assess any penalties for failure to pass along the wage increase funding. So what this bill proposes to do is give the department the statutory authority to impose a civil penalty of up to 50% of any such rate increase that was not used for employee wage enhancement. So we would recoup the amount of dollars that were provided to the facility for the wage enhancement, and then have the discretion to assess a penalty of up to 50% of that amount for failure to pass along the wage increase to employees. We also note that the department would not want to impair the cash flow at a nursing home to such an extent that they would that it would impact patient care. So we would also have the authority to set up a repayment plan with the nursing home to recover not only the wages that were not passed along, but also this civil penalty. Senate Bill 283, an act eliminating income and asset limits for the MedConnect program for persons with disabilities. This proposed legislation would seek to eliminate both income and asset limits for working persons with disabilities in order to qualify for Medicaid. Currently, the Medicaid program for employed disabled individuals, or MedConnect, allows certain Connecticut residents with disabilities who earn up to $75,000 a year to qualify for full Medicaid coverage under our Husky C program. As of January of this year, there were 3,600 individuals enrolled in MedConnect, 3,617 to be precise. Individuals in this program who earn above 200% of the federal poverty level pay a premium for their coverage. Currently, there are 895 MedConnect enrollees that have a premium obligation. MedConnect also allows eligible individuals to work and retain assets greater than what is allowable under traditional Medicaid coverage. The program includes a $10,000 resource test for individuals and a $15,000 resource test for married couples. But the resource test excludes home property, certain retirement accounts, ABLE accounts, which are specific accounts for individuals with disabilities who can save for certain purposes, and accounts maintained for the purpose of increasing employability. So there are some significant exclusions to the asset test already. It is difficult for the department to know exactly how many additional individuals would qualify for Medicaid for this to pass. If we were to assume the average monthly cost per person of approximately $575, a modest increase in enrollment of 10% would result in a cost of over $1 million to the state. Would also likely encourage individuals currently covered through their employers and private insurance to move to Medicaid due to its broader coverage and lower cost sharing. So the enrollment increases could be substantial, resulting in significant costs that are not currently included in the governor's budget. For this reason, and without the availability of appropriations, the department cannot support the bill at this time. SB 285, an act concerning time limits in the temporary family assistance program during a state public health emergency. This is a technical change in the last session of Section 347 of Public Act 2112. Amended 17B112C to provide that months during which a household receives TFA during the public health emergency declared by Governor Ned Lamont related to COVID-19 shall not count towards the time limits for such program. This bill simply proposes to add a public health emergency that results from legislative action in addition to one declared by the governor. Would also result in exclusion of those months from the TFA time limits. So the department obviously supports this change that would allow us to continue to implement the TFA exclusions through the end of the current public health emergency. SB 286 is an act concerning deadlines for mandatory reporting of suspected elder abuse and penalties for failure to report. These proposed changes are in response to recommendations of the 2021 performance audit of protective services for the elderly. The proposal would do two things. First, it would reduce the mandated reporting time frame from 72 hours to not less than 12 hours. And second, it would require mandated reporters who fail to report maltreatment within the required timeframes to retake their elder abuse training and provide the program with proof of successful completion of such training. For the committee's context, we note in our testimony that this timeframe is consistent, congruent with our surrounding states. Timeframes in Maine, Massachusetts, and New Hampshire simply state that the suspected abuse or maltreatment should be reported immediately. Rhode Island and Vermont have a 48-hour timeframe for reporting. So the department believes that this will continue to encourage prompt reporting of suspected elder maltreatment, and we urge passage of this bill. SB 288 is an act exempting Medicaid waiver and state plan amendment submissions filed in response to a declared public health emergency or disaster, be exempt from notice and public hearing requirements. This is something with which we all have immediate experience in the past few months. As you know, during a federal public health emergency, our federal partners, the Center for Medicare and Medicaid Services, allow states on an expedited basis and without providing a notice and comment period to take advantage of certain specific expedited federal approval processes. These expedited processes apply to amendments to the Medicaid state plan, so-called SPAs, to waiver amendments, to waiver applications, and expedited changes to other federal authorities. The reason that these expedited authorities exist at the federal level is to allow a faster approval process and allow the funds to flow quickly from the, as well as the approvals to flow quickly from the federal government to the states. However, despite these federal exemptions from notice and comment periods, the 17B8 of the general statutes requires in Connecticut a 30-day period for notice and public comment, including publication in the Connecticut Law Journal in advance of hearings before the Joint Standing Committees of Cognizance prior to submitting the necessary federal applications for CMS. We did waive our state required public notice and comment period earlier in the pandemic under Executive Order 7S. That has since expired. So this proposal simply would allow that in the case of the remainder of the existing public health emergency and importantly, any future public health emergencies, the department would have the ability to waive the state required public notice and comment period. I want to make sure that the committee understands that there is a safeguard here, which is that in all cases, if DSS were to seek to make any of these authorities permanent, the regular notice and comment period would apply. And the committee public hearing and review process under Section 17B8 would still apply. So there would, as there will be with many of the Appendix K and disaster SPAs that have come before you over the course of the pandemic, if any of those are to remain permanent authorities, they will come before you again under the normal process. SB 289 is an act concerning oversight and funding of the Connecticut Fatherhood Initiative. This is a proposal that really just codifies the existing structure and partnerships of the Connecticut Fatherhood Initiative. We are delighted that Senator Moore has been working with us closely on this initiative over the past many months. And the language in this bill simply articulates the partners and elements of the Connecticut Fatherhood Strategic Plan, which we hope will continue to strengthen the initiative and allow the department to continue to work with our many partners. This is an initiative that focuses on engaging, in many cases, non-custodial fathers with their children and families and provides supports to them. We work closely with DCF and other partners across the state and think that this legislation would further support the program. So we urge passage of this bill. SB 290 is an act concerning certificates of need for long-term care facilities. Many of you know that in the wake of the pandemic and the many, many challenges and changes to the nursing home industry, the department is receiving a fairly unprecedented number of certificate of need requests for review and approval. This legislation would do three things. One is that it would explicitly allow the commissioner to include conditions in a decision approving or modifying a certificate of need. For the committee members who may not be familiar with the certificate of need process, If a nursing home applies to the department for a modification in the services or number of beds in their facility and the department approves it, any costs associated with that are then allowed to be incorporated into the fair rental value that's charged to the department as part of our nursing home reimbursement. So it has been the department's past practice to include conditions in CON approval, but it is not explicit in the legislation. So the first component of this bill would codify that the commissioner can place conditions on the CON approval. The second is a technical adjustment that adds some language to subsection B of 17B 352 to provide consistency across the statutes. It just adds some reference to clarify what is being referred to in that section of the statute. Third, consistent with DSS's strategic plan for long-term care, we are proposing to add language to 17B 354A that encourages more nursing facilities to establish non-traditional small house style nursing facilities. There is a movement in the nursing home industry to build and support smaller, more home-like types of facilities, sometimes known as greenhouses. They have been shown to have high resident and family satisfaction, as well as improved clinical outcomes for residents. We would like to encourage the development of these greenhouses here in Connecticut. So this proposal provides an exception to the moratorium on applications to increase nursing home beds if a facility proposes to build a non-traditional small house style nursing home, provided that they are agreeable to reducing total licensed beds by a percentage established by the commissioner in accordance with our long-term plan. Finally, the proposal would require the, excuse me, let me just orient myself here. 17B 35, we propose revising that section to establish additional criteria for the commissioner to consider when evaluating CON applications, to relocate existing beds to a new or replacement facility and ensure that any proposal to build a new or replacement facility is consistent with the strategic plan for long-term care. The existing statute is fairly broad in terms of the conditions and considerations for the commissioner, and this would add additional language to make it clear that decisions need to be consistent with the strategic plan. The proposed language would require a nursing facility that is relocating nursing home beds from an existing facility to a new facility to close at least currently one licensed facility other than the facility that's being replaced. The commissioner may also request that any applicant seeking to replace an existing facility reduce the number of beds in the new facility by a percentage that is consistent with the department's strategic plan for long-term care. We believe that these proposals will assist the state not only in continuing to work with the industry to right-size our nursing home beds, but also support higher quality and more patient-centered care in our nursing homes. So we urge passage of this bill. I'm almost at the end. HB 5332, an act prohibiting home care agency contract staff that penalize, home care agency contracts that penalize clients for directly hiring agency staff. So as you know, in our system, we have agency-based personal care attendants and direct hire or client-employed personal care attendants. This proposal would prohibit agency to have so-called no-hire clauses in their contracts with clients. Such a clause would prohibit the individual from hiring an agency-based PCA to be their direct employee under a self-directed program and could impose penalties. We think those penalties would be a hardship for our Husky clients who are predominantly low-income individuals, and also prohibit their freedom of choice between a self-directed and an agency-based program and hiring the PCA of their choice. We believe that this will assist clients in having the PCA, the personal care attendant services of their choice, and urge passage of this bill. HB 5333 is an act concerning the program of all-inclusive care for the elderly. This bill would permit DSS to submit a state plan amendment to add a PACE, so-called PACE program of all-inclusive care for the elderly into the Medicaid state plan, as well as establishing participation criteria for eligibility. PACE is a program established by our federal partners. It integrates Medicare and Medicaid funding for services to help people meet their healthcare needs in the community instead of going to a nursing home. This is a national program. With PACE, there's a team of healthcare professionals that work to deliver care through a coordinated model. In many states, PACE provides an additional community-based option, which plays an important role in the long-term services and support continuum. The department is very interested in exploring with the committee and with our partners in the industry what it would be entailed in establishing a PACE program in Connecticut. We need to understand, I know from having worked in another state with a PACE program that it does require additional staff at the department for oversight. But we also need to examine the costs that could potentially be involved to adding a PACE program to our state plan. And finally, HB 5341 is an act equalizing Medicaid rates for providers of inpatient mental health services in Eastern Connecticut. This bill would require DSS to compare rates for providers of inpatient mental health services in Eastern Connecticut to Medicaid payment rates for such providers in other areas of the state, and to adjust rates as necessary to achieve parity. I would note for the committee that our rates for inpatient psychiatric services are paid on a day-by-day basis. They were established in 2015 at the time when our hospital payment system underwent a change. And they were based on reported costs by the institutions, not by geography. Typically, we do not set our rates in Husky based on the geographic location of the provider, but rather we follow the methodology in our state plan. And in this case, the methodology required the facilities to report their costs to us, and the rates were based on that. We have done a brief survey of rates and note that geography is not necessarily correlated to rates. A few examples: Charlotte Hungerford Hospital in Torrington is one of our, in our higher cost tier. Day Kimball Hospital in Putnam is in the middle, and Greenwich Hospital is in the lowest tier. However, we do note that Eastern Connecticut hospitals are generally in the lower tier, most likely given their historical cost basis. We would be happy to provide the committee with all of our inpatient mental health rates for review, if that would be helpful. Since this methodology would not be supported by our current approved federal state plan for setting hospital rates, and any adjustments to the rates are not currently in the governor's budget, the department does not support this bill. Madam Chair, that concludes my testimony.
Good job, Commissioner. That was a lot. We should call it DSS Day.
It was a lot, and I would like to thank the very hardworking team at DSS for preparing all of this testimony and doing our best to give you all the information that you need.
Thank you. Yes, they are a hardworking team. So thank you to the DSS team that's on the call. Open to questions. Representative Hughes.
Thank you, Madam Chair, and thank you, Commissioner, for that detailed testimony. I just wanted to ask a little more, since I didn't know that you had worked in a state with PACE. Would you consider this model basically updating the way that all-inclusive settings are? Would it be an update in your experience to the way that I know Leading Age wants this, and I don't really understand the history in Connecticut of why we haven't had a PACE model. So maybe you could talk a little bit more about that.
I also know that there have been waxing and waning interest in Connecticut in the PACE model. It requires a provider that's willing to undertake it, as well as the the permissive statute that's before you. My understanding from both my other state and federal experience is that the PACE programs vary one to the next in terms of their quality and their ability to provide comprehensive services. The program with which I'm familiar was an excellent alternative to institutional care. It was high quality, and full disclosure, because I always like to say that I was not an employee of the PACE program, but my husband was their medical director for a period of time. He's a geriatrician, so hence my familiarity with the program. So I think it merits exploration. I would note for the committee that it's very different in terms of how we pay, in that it grades both Medicare and Medicaid funding. So right now, Medicare pays separately for the services they cover. DSS will pay separately under our state plan services. We do not in our state yet have a model that blends these two. PACE does that. And that allows some flexibility to the provider in providing enhanced services that can be very beneficial.
And would you recommend it as a model for our complex care patients that have both Medicare and Medicaid?
With the caveat, Representative Hughes, many caveats, including understanding the available funding and the potential change in the budget, I would recommend that it's a model worth exploring. Yes.
Great. Thank you. Thank you, Madam Chair.
Thank you, Representative. Representative Master Francesco.
Thank you, Madam Chair. Thank you, Commissioner. It's nice to see you. I would have to say that I always enjoy your testimony. You are very thorough. Although I don't always agree with your position on them, I do appreciate the work that you put into it. It certainly gives us a lot of information. I did miss a little bit in the beginning. I was a little late coming in, but I did follow along for what I have. And there was one bill in here that kind of stuck out to me that I had a few questions on. And that was 5332, an Prohibiting home care agency contracts that penalize clients.
Mm-hmm.
So if I understand this correctly, a home care agency has personal care attendants that work for them. They work for the home care agency. The home care agency trains them, provides them all the tools that they need. This personal care attendant, and they contract with a client, a family.
Mm-hmm.
That personal care attendant goes out there, cares for the family member, and now the family, the client, does no longer want to go through the home care agency. They want to hire that personal care attendant directly. Is that correct?
That's correct.
Okay. So my question is, the home care agency hired them. They work for the home care agency. They've trained them. They've invested a lot of time, hours, and money into that person. Mm-hmm. I guess I'm confused, and I'm just baffled by why the state feels that they're not allowed to do that. It's a private contract with the agency and the family, that they have it in their contract that you can't hire directly the PCA, the attendant that's taking care of you. That's a personal contract between the family and the agency. Mm-hmm. If the family wanted to hire somebody not involved that does not work for an agency, they could certainly go out and seek that. So I'm just trying to understand why that why the state feels that they need to interfere with that contract. Are there any problems? Do we have any issues? Is there any data, any statistics, dollars, something that the state would need to interfere with a private contract between an employer, an agency, and a family?
Thank you, Representative. And I appreciate your kind comments about the testimony. And again, all credit goes to the team. So, but it's kind of you to acknowledge. With respect to this, I think that the department objects on a couple of bases. One is the penalties, which can range from $5,000 to $10,000, which is a financial hardship for Husky recipients. Secondly, the efforts of the department around home and community-based services are founded a lot on choice and on the choice and agency of the individual who is receiving the personal care. Our self-directed program, in fact, is based on the notion that individuals who are receiving these services have the right to hire the person of their choice to provide these very personal, often intimate services to them. So while we don't, I think we see this question through a slightly different lens than the one you described, which is that both the personal care attendant, him or herself, and the client should have the right to engage in this self-directed type of relationship if they so choose, rather than be bound by a punitive contract through a home care agency. I certainly appreciate that home care agencies want to retain highly competent personal care attendants on their teams, but we don't think that that would trump the rights of both the personal care attendant and the recipient of services through Husky.
Thank you. So
you're welcome.
So I would disagree in a couple of things. Is one, the agency does have a choice, and so does the personal care attendant, and so does the family. They're signing a contract with that agency knowing full well that there could be a penalty if they go out and try to hire the personal care attendant. So they clearly know, so they do have a choice. They have a choice to either sign the contract or not sign the contract. So I'm just not a personal, I just find it really egregious for the state to get involved in something like that. You had mentioned something else about, did you mention that there were the penalty that the state thought was too high, $5,000 and $10,000?
Yes.
Did I hear you say that?
Yes.
So again, I don't know. I got to tell you, of all the bills that I see here, I just find this to be the most offensive. It's a private business. They have a right to contract with their employees and their clients, in my mind, any way they choose. And if the client feels that that penalty is too high, they don't sign the contract. So I'm just curious, do personal care attendants have a way to go out on their own and not work for an agency? Because clearly they have the right to do that as well. Do they have a ways to do that?
Yes, and that is exactly what we're talking about here. They have a right to be directly hired by a Husky client in our self-directed program. And if the problem is that such no hire clauses currently might prevent both the PCA and the client from hiring the PCA of their choice because of these penalties.
So again, but the employee clearly knows when they're being hired what the requirements are from the agency. So are you saying that the personal care attendant, instead of going through an agency, and they have a choice now, because they always have a choice, nobody forces anybody to do anything. They can go to the self-directed program and just instead of working for an agency. Is that correct?
Yeah.
Okay. I don't know. I just think this is really, truly an intrusion and invasion on a private business, and you're kind of holding them hostage. I mean, it drives me crazy when people say that they don't have a choice. They do have a choice. The agency, the employee, and the family absolutely has a choice. And I I'm not lashing out at you, but it just drives me crazy when people say they don't have a choice. Everybody has a choice in this world. This is the United States of America. We're a free country. So I just find this piece of legislation very intrusive. But I truly appreciate your testimony. Again, you're very thorough, and I don't mean to lash out at you. It's just very frustrating when I see things like this come before us. But thank you very much, Commissioner. Thank you, Madam Chair. I appreciate it.
Thank you, Representative. So Representative, just for a little bit of clarification about where this bill came from and why it's so important, I think you're missing a little bit of a piece of it. We're talking about non-compete clauses in a contract that is not in any other human services contract. We don't do it in the human services field. We're taking a low wage worker and asking them to sign something. And our understanding is a lot of times they don't even understand what non-compete means. This is a bill that's been around. We had this bill that we had non-compete clauses prohibited from workers last year or the year before. What the home care providers did was now they're going after the families that are hiring these workers. So they shifted from the workers to the individuals. So just for clarification, I want you to understand where this bill came from and why it's important. It's no different than saying if you go to work at McDonald's, that they're going to have you sign a non-compete clause that you can't go and work at Burger King. It's a free market, and that's why this bill is important.
Right. I appreciate you clarifying that, Representative, but I guess we just disagree on, I don't know, a free market. I just believe that it's an business. They do the training. They have a right to sign a private contract with the employee. And certainly the employee has a right not to sign it. So I understand where you're coming from. I don't agree with it, but I certainly understand where you're coming from. Thank you.
Yeah, and just remember, this is all, a lot of this is state money. This is Medicaid. So if they weren't getting the funding from us, I would probably agree with you that it's a private market, but it really isn't. You know, it's no different than rules we put in place for nursing homes, in my opinion. But I do appreciate where you're coming from on this issue.
Thank you, Representative.
You're welcome. Representative Case.
Thank you, Madam Chair, and I apologize, Commissioner. I was trying to get on two different meetings and I couldn't get on, so I missed your commentary on the last bill that you were talking on. And was that 5341? You were talking about the tiers?
Yeah.
So you talk about the tiers. This is, and Madam Chair, I think this has come up in front of us a couple years about the eastern side. You were mentioning out some particular facilities and their rates of pay. So how does it affect across the board as far as what's going on in the western part of the state and what's going on?
Yeah. Yeah. Okay. And I might have added some more context on the tiers, so I appreciate you bringing it up, Rep. Case. In 2015, bear with me because we're about to go into Medicaid rabbit hole, but in 2015, the state transitioned from paying every hospital on a day basis. Like you're in the hospital for 5 days, you get 5 times whatever your hospital's rate is, to a so-called diagnosis-related group. This is how the vast majority of the country pays for hospital stays, and you get paid a fixed amount based on the diagnosis plus minus complications. We transitioned to that system for the majority of our hospital payment, with the exception of inpatient psychiatric services, which are still paid on a daily rate. I wasn't here in 2015. Perhaps some of you recall why that decision was made, but in any case, we continue to pay hospitals for psychiatric inpatient services on a daily rate. Now, how did we establish those rates? We established them, Rep. Case, in the same way that we do, as you know, for most of the cost-based reimbursement that we pay, which is we ask the facilities, give us your costs. We take a look at them. We look at what's allowable and what's not allowable based on our federal requirements, and then we establish a rate. Now, those rates were then bucketed back in the day into 3 tiers. Bill was around, so he'll jump in if I say something erroneous, into 3 tiers. And so now we have 3 tiers of payment based on those costs that were reported to us. The point of that long story is it's not based on geography. And the reason I gave some of those examples is because you see smatterings of all the different tiers all around the state. That being said, we did notice that there are lower rates in general in the eastern part of the state. Those would have been based not on the fact that they're in the eastern part of the state, but that the methodology we used based on costs was resulted in those lower rates. So that's how we arrived at where we are today, Representative Case. And the reason I say I bring it up is because we can't typically, without consulting with our federal partners who have, 50% of the skin in the game, we can't typically simply change the way we pay a particular provider group without an underlying rationale that's founded in our state plan.
So with looking at that a little bit deeper, when you see a lot of this consolidation that's going on and a lot of these smaller hospitals that are being brought into the bigger realms, I think my concern is there's such a disparity between one side of the state to the other. And we're all residents of the state of Connecticut. I just don't get what the cost difference is and why there's such a high tier and then there's such a low tier. But now you have all these larger facilities taking in these smaller facilities. Why isn't there one payment across the board?
Well, the diagnosis related group is meant to achieve that for hospital rates writ large. I don't know, Bill, if you want to provide any color commentary on why we retained that different strategy based on costs or daily rates for the psych inpatient.
Sure, thank you. Bill Halsey with DSS. So we didn't, first of all, we didn't move over to the DRG methodology for psych inpatient because at that time, in consultation with the hospital association and the hospital, we didn't see the predictability on the psych side in terms of the same predictability on the medical side. So that's why we stayed with a per diem rate on the psychiatric inpatient side. I'll also say that I would confirm that many of these rates are based on the information provided by the hospitals and in many cases pretty historical rates, and the ranges were quite large in 2015. And when we went through this methodology, we tried to reduce that range, but we couldn't close the gap all the way. There would have been significant winners and significant losers. So we decided to keep 3 basic tiers of reimbursement for the hospitals. And we'd be happy to provide you the full provider specific rates so you could see the scattering of rates throughout the state. And it's not necessarily geography based per se, but to the commissioner's point, if geography played some part in perhaps reduced costs, then that would have had an impact.
So I guess basically what this bill is doing, and correct me if I'm wrong, Madam Chair, this bill is basically looking at to try to equalize and change what the way it's being paid out now, just because the eastern part of the state is feeling as though they're not getting a fair shake. Is that what I'm getting at?
You asking me, Rep Case?
Sure.
Yes. The bill would direct the department to do a study and then achieve parity. So, that definition is a little bit unclear. So I think, again, we would need to establish not only the funding, but we would need to establish a rationale for why we would use geography as a basis for adjusting rates rather than something more typical in our rate methodology.
It's just we've seen this a few years on our agendas coming forward, and I just wanted to get to the bottom of it and why things aren't. And there's a lot of things in this legislature that are looking at parity, And
Yeah.
especially in the DSS world, because people feel as though the services aren't any different in one part of the state than the other. Everybody needs to get the care. So I thank you for that. And once again, as everybody else said, thank you for your testimony. It's almost an hour in, and it was very clear. But thank you, Madam Chair.
Thank you, Representative Case. Representative Dathan.
Thank you very much, Madam Chair, and thank you, Commissioner. It's always lovely to see you, and you are so thorough in your testimony. It's really great. So thank you, and to you and your team for always coming and giving some great work here for this committee. I have a couple of questions that are kind of residual from other people's questions. The first one has to do with SB 194. And the contracting with social services to other states. You had mentioned in your testimony that DPH also does this as well. And I just wanted to get an understanding what sort of parameters were in place for this external outside of Connecticut to contract with, in terms of, does the state first have any obligations to look inside to Connecticut and to make sure that we're able to look to our, let's say, for research services at UConn or Yale or other places before going to outside? Is there any contracting provisions as part of this?
So, Representative, we are not requesting any change to the procurement process. So we, as a matter of course, with some rare exceptions, do competitive procurements. And so what we're saying is, if we do a competitive procurement and through that standardized set of processes, the awardee is the applicant and preferred awardee happens to be another state entity, that we not be precluded from entering into a contract, which is currently the case.
So currently, you're precluded to working with someone in outside Connecticut as part of the work that you're doing? Because I wasn't just in my work in appropriations and understanding the procurement process that we have at DAS, I didn't realize that that was the case.
We're not, to clarify, we're not prohibited from contracting with any out-of-state organization. We contract with many out-of-state organizations as a result of competitive procurements, but a state entity. So in the example that I cited, University of Massachusetts, which is like UConn, a state entity, we would not be able to contract with for services.
Got it. So in DPH, for example, they're able to contract with the state of Massachusetts if we needed to get additional masks or testing that we didn't have. Is that what you're saying?
Yes.
Okay, great.
In our testimony, as the statutory citation for the DPH language, if that's helpful, but it explicitly says that they can enter into a contract with another state for facilities, services, and programs.
Okay, thank you for that. My next question is about SB 281, and it's regarding penalties for rate increases that are earmarked for staff. I know that the basis of this bill was based on the 2021 legislative session that designated increases, but why are we limiting this in general just to nursing home facilities, and why is there any other thing in place that would say that, you know, if the legislature does pass on rate increases, no matter which industry we're talking, if it's, you know, group homes or other sort of places, maybe other sort of recipients of DSS services, why are we limiting to just nursing home facilities here?
Yeah. It's a fair question, Representative. I would say, I think the main reason is that that DSS has the existing authority and the administrative structure to receive cost reports and do audits of nursing homes. We don't have that for all provider types. So I take your point. I think it would be, in the case of group homes, for example, the majority of payment would go through other agencies. So I think that the primary reason for limiting to this is, I think it's been at least come to our attention.
Ooh, I think you're frozen, Commissioner.
Bill, do you want to continue for the commissioner until she's unfrozen? It looks like all of DSS froze.
I was going to say, it looks like everybody is frozen over there.
Uh-oh.
There's the sun.
Oh, and now we lost them all.
Oh,
There
there
we-
she-
Hello, Commissioner. We just lost you mid-sentence.
Sorry, I got booted. I don't know where I last left you, but I was saying, Rep. Dathan, that we have the administrative structures to both audit and monitor cost reports in nursing homes to an extent that we don't have for all provider types.
Okay.
And that was, and other agencies are involved in payments to other providers. So that was primarily our reason for limiting it to nursing homes.
Okay, are you aware of, does DDS or DPH have anything like this with rates that might, just wondering, outside of DSS, is there could there be an issue? And maybe you can't answer that question, and it's, I need to ask
I think
another group.
I think it's worth, I'm not aware of any, let me put it that way, but I think it's an appropriate question.
No, I'm sitting, and apologies to my chairwomen, just sitting as well with my appropriations hat on, because I know this is something that we talk a lot about. So I appreciate you giving that answer, and I will let my other colleagues jump in. Thank you, Madam Chair.
Thank you, Representative. So just a little bit of clarification on this bill. So nursing homes was the only organization provider out there that we heard over through the pandemic that dollars were actually earmarked for increases for salaries. Normally, we don't do it that way. It goes into rates, which is a payment system, and through the audit process, we know that the providers are doing it. So that's why this language is very specific to nursing homes, because we knew there was a problem. Even though I will give kudos to DSS, when we did these increases, they shortened the time period to do an audit to make sure that they were spending the dollars wisely. Since then, there were 2 or 3 more pockets of money that went out to the nursing homes. And through that process, we heard from many workers that the money did not flow down to them. So I think, Representative Dathan, I think it's a good question to ask the other agencies, but the way the payment is structured, it's a little different, and this is a unique situation.
Great, thank you for that, Representative Crombie. Thank you.
You're welcome. You're welcome. Representative Master Francesco, I'm going to go to Senator Moore because you had asked one question already. Thank you, ma'am. Senator Moore.
Thank you. Thank you, Commissioner. Always, you bring your troops with you, but you have a lot of information that you provide very clear. I want to go to Senate Bill 281 that we were just discussing. So help me understand. So there was funding provided to these providers. They didn't pass it down to the workers. And now there's going to be a penalty for them. 50% is what you said?
Yes.
When does the money get back to the worker? I mean, where are they in this loop? When do they get their funding?
It's a really good question. And the intent Senator, is that by having this financial penalty, which exceeds the amount that the home is given to pass through to the workers, that there will be an incentive for them to actually pass it on. Right now, if they receive, let's just say the nursing home receives $100 from DSS, and that's earmarked to give a raise. We can take back that $100. The worker doesn't get their raise, but the state money has not been inappropriately given to them. They haven't been able to keep that for other purposes. What this bill would propose is that we would take back the $100 and then penalize them another $50. And these amounts are sufficiently large that the intent is that that 50% penalty of the total amount would incentivize the owner to do the right thing and pass the money along to their workforce.
Okay, I get that piece, but there's nothing here that sends those wages back. Even once they didn't perform or didn't apply the money the way they were supposed to, there's still a loser on the end of this, and it's the employee is never going to see their money.
That is unfortunately correct, Senator.
Is there an opportunity when you call back that 50% of that money to get that money to the employee?
I don't know how we would do that, Senator. We don't have a relationship with these individuals. They're not our employees. They're not, it's a private business, and the relationship is between the employer and the employee. So assessing this civil penalty is our way of saying, if you don't follow the state's mandate around wages, there will be some level of punishment, but we don't have any direct relationship with the employees.
And is the employee aware of the state awarding additional funds to the provider, that they would know that they should be getting an increase?
In general, in this most recent case, I think it did come from the employees and their union representatives that this had not been passed along. That's not, it's typical that we would hear from employees that they haven't received their raises.
And were the employees aware, because of the many talks and calls we've had regarding unfair wages, unfair conditions for the nursing homes and those workers? Is that how it comes to light?
I honestly, Senator, I can't really speculate as to how they learned. I don't know exactly how they came to know that they were owed that 4.5%.
And do you know how many agencies or how many providers have not passed the wages on to their employees?
Bill, do you know that? I think we had maybe 2 in this most recent round, and then I know of at least 1 case prior to this from another payment increase.
I think we're currently working with 2 right now.
And so is there any recourse for those 2 before this bill's passed for those employees?
We are working actively with those facilities to try to convince them to release those dollars to those employees.
And could they be impacted by this bill if they don't?
Yes, it's retroactive to the increase that was passed last session, Senator.
Okay. Well, maybe that'll light the fire under them. Thank you. And then I just want to comment on, and this is really self-promoting, on the Fatherhood Initiative, that this is really very important. I co-chair it with Commissioner Gifford, as she said. I looked at the report that they gave out on the history since 1999 and how little staff they have, but how many members and how many other people are involved in this. And it falls in line with the 2-generation initiative that we started about 5 years ago, making sure that we're looking at the whole family and involving fathers in everything and having the support needs that they need. So I'm thanking you for doing this. I'm hoping we can get this together and pull this together for all the members to strengthen it. So thank you. Thank you to your team. Thank you, Madam Chair.
Thank you, Senator, for your questions. I agree with you. Commissioner, just a quick question to follow up on Senator Moore. So in 2020 is when we started giving the nursing homes in the height of the pandemic these added dollars. And I know that you guys did some audits then. We didn't have any issues then. It just came to light in 2021, correct?
There was at least one, and we can get you more precise information, that had not passed on the minimum wage increase. So we had added dollars to our rates for the minimum wage increases prior to the pandemic, Representative. And we know of at least one case where that wasn't at least timely passed on to the workers. So this came to light most recently again, which prompted us to make this proposal, but it had happened before with the minimum wage increases as well.
Thank you. Thank you, Commissioner. Representative Master Francesco.
Thank you, Madam Chair. I'm sorry, when I got off, I had a couple of more questions that just came to me, just for clarification. So the going back to 5332, this bill, if an agency contracts with a family that is not a Medicaid recipient, should this bill pass, would this apply to them as well?
I don't believe so. Is there Peter or Graham or Bill? Do you know the answer to that question? I believe it's only for Husky members. Yeah. It will eliminate the possibility that a Medicaid member who wishes to hire their caregiver will be forced to pay a penalty. Representative, in general, the self-directed model really only applies to Medicaid. I'm not aware that that exists through any other funding source. So I think it's generally only relevant to Medicaid, but I don't believe it would have any effects beyond Medicaid recipients.
Okay, and then what percentage of Medicaid reimbursement on the federal and then the state portion of it? What is the percentage? Is it like 60% we get from the federal reimbursement and the state funds the other 40%? What is that?
Well, yes, in general, we're at about 56%. In the Community First Choice program that this self-directed is part of, we have an enhanced match rate, which is, I can get it to you unless Bill knows it off the top of his head, closer to 60%, I believe.
60%. And then for Medicaid reimbursement on the federal level, the money that we get, is there anything in their language that's similar to what is being proposed here? In other words, would we not get federal dollars because of a contract with an employer, a private agency and a client?
I'm not aware of any federal requirements. Are you,
So
Bill?
I'm not.
Okay, so this is just clearly a state initiative. It has nothing to do with the federal government on their initiative. Okay, thank you very much. I appreciate the extra questions, Representative.
You're welcome, Representative. Any further questions or comments from committee members? Well, thank you, Commissioner, and thank you to your team. We really appreciate you guys being here today. This was a lot in one session, but we thought it'd be easier in this public hearing to do all of the DSS bills at once. So thank you very much and have a great day.
Thank you, Representative and members of the committee. Appreciate it.
So because we're past our first hour, we're now going to go to the public and then rotate back to the elected officials or agencies. Just to remind everyone, for the public, you have 3 minutes. When your 3 minutes are up, our new clerk, Cass, will come on the screen and please ask you to wrap up. So with that, the first person up is Holly Hackett. Hi, Holly.
Hello. I wasn't expecting to be first because I'm number 6. My apologies. Can everyone hear me? Uh-oh.
We can hear you, Holly. Please
Oh,
proceed.
okay. Thank you. I'm sorry about that. I wasn't sure if you guys were able to hear me or not. My apologies. Thank you so much. Okay, I will start. My apologies. Good afternoon, Senator Moore, Representative Abercrombie, and distinguished members of the Human Services Committee. My name is Holly Hackett. I'm a part-time office administrator for Keep the Promise Coalition, or KTP, and a registered voter in East Haven. For those of you who are not familiar, KTP is a statewide coalition of advocates with lived experience of mental health, addiction, and co-occurring conditions. Their family members, mental health professionals, and other interested community members dedicated to ensuring that a comprehensive community-based mental health system is created and sustained across the lifespan. I am not just testifying on behalf of what I've heard our members go through, but I am testifying in favor of SB 283 on behalf of myself as a person with disabilities. To make the greatest difference for those of us who are disabled and the elderly, I am suggesting that you consider bringing Husky C income and asset limits to at least that of Husky D, which is currently 138% of the federal poverty level, and asset limits to $5,000 for single and $7,500 for married. Because I, like many, never know how long I will be able to remain stable enough and working. So I have to try to save money or pay down my credit card debt so that I have room for medical expenses. This is because when I go back to having just Medicare A and B and qualified Medicare beneficiary, or QMB, I lose all the dental, vision, hearing, and the more robust behavioral health care services and at-home health benefits of Husky C. The things we advocates usually hear from legislators is, we cannot afford to do that, or it will cost too much. Although I still don't understand how you can say those things when you're referring to human beings and their quality of life. However, for the next few years, you guys will not be able to say that to those of us in the advocacy world because of all the ARPA funds and how really well the stock market is doing for our retirement and all the extras that we have now here in Connecticut. The truth is that it is much more expensive if you do not start covering these services for the elderly and disabled. The cost of a person not having dental coverage and having to go to the emergency room for an infected tooth that ended up spreading into the bloodstream is much more expensive than dental that would have prevented the tooth from becoming infected. It is a lot less expensive for prescription glasses and refractions than to cover neurology visits for CAT scans, MRIs for headaches caused by your glasses needing to be changed. There have been studies done that showed hearing loss may contribute to dementia, which we also know is a very, very expensive situation. And also the hearing causes walking problems and falls, which is costly for emergency room visits, transportation, surgery, physical therapy. As far as being able to receive at-home care, I'm sure you are all aware that a lot of times these services allow people to stay at home instead of having to live in long-term care facilities. And we know how very expensive those are. So perhaps I would ask you all to start thinking when it comes to human beings and their health. We cannot afford to not do more. Thank you for listening. Oh, sorry. I was just about to tell you that your 3 minutes is up. Thank you.
Thank you. Thank you for listening to my testimony in support of SB 283 with a suggested amendment to increase the asset and income limits of Husky C. Are there any questions?
Thank you, Holly, for your testimony. We appreciate it. Rep Hughes?
And thank you, Holly, for your lived experience, especially in terms of those Husky C and D thresholds. Were you talking about that too?
Yeah.
I wanted to know if that threshold changing would create more economic stability for those like yourself. Like tell me about that. Tell me about what that would look like in terms of the long-term stability.
Well, because I have straight Medicare and QMB, my eyeglasses are not covered, my refractions are not covered. I have not been to a dentist and I can't tell you how long. And I went once and it cost me over $1,000. And again, that's on my credit cards because I don't have the money to do it. And again, every year, because of my medical conditions, I have my prescriptions changed. So every year it costs me between $700 and $1,500 for my glasses.
So every year I rack up credit card debt of between $700 and $1,500 for my glasses because of how complex my prescription is.
And did you say that you're also working intermittently, and how would that allow you to keep working? That's my real question.
I haven't started to do that yet because I've only been working for a short time. And to be honest with you, Rep Hughes, I haven't been paying attention because it's too complex. So unless my doctors send me a bill and say, hey, this is what you owe, I don't pay attention because all the paperwork gives me a headache.
Sure.
And
It gives me a headache.
yeah, although I am in the advocacy world,
Yeah.
I had a caseworker to do my paperwork for me, but I
Perfect.
no longer have a caseworker.
Okay, so we're talking about a lot of bureaucratic barriers to both the care, but also increasing that asset and income limit would support your economic self-determination in the long term,
Yes.
correct? Yeah.
Yes,
And
absolutely. Yes.
because a credit card debt is not a sustainable strategy for economic security and self-determination.
But
Okay.
that's all I had. That's all
Yeah.
I had.
And I suspect you speak for a lot of others who are sort of in that same gap of thresholds.
Yes, and I moved back home with my mom because she's worse than I am. She has an income a little bit higher than mine, so she doesn't even qualify for QMB. So she had to go into, that lovely the cutthroat one. Oh God, you know what I'm talking about, Rep Hughes? I can't think of it. Oh, Medicare Advantage plan.
Mhm.
Where she doesn't get all the services she needs and deserves.
Got it.
So that's where she is, but I'm here because we can't afford our expenses on our disability and our retirement.
Thank you. Thank you so much, Holly, for your experience. Thank you, Madam Chair.
Thank you,
Thank you, Rep
Representative.
Hughes.
Any further questions or comments? Seeing none. Thank you, Holly. Have a great day.
Thank you, guys. Take care.
Now we're going to go back to the commissioners. Commissioner Porter. Good afternoon.
Good afternoon, Representative Abercrombie, and also good afternoon to Senator Moore, Senator Berthel, Representative Case, and distinguished members of the Human Services Committee. My name is Amy Porter, and I'm the Commissioner for the Department of Aging and Disability Services. I'm also joined by a couple members of my staff, Andrew Norton, our Legislative Liaison, and Margie Gerendo-Marquette, who is the Program Manager in our State Unit on Aging. I am just here to talk about one bill today, and I thank you for the opportunity to offer testimony on House Bill 5332, an act prohibiting home care agency contracts that penalize clients for directly hiring agency staff. I know you've had some conversations about this already. We strongly urge passage of this important bill. The proposal will strengthen consumer rights. It allows for greater choice in home care services and really strengthens our overall home and community-based service system. The bill is designed to prohibit home care companies from imposing financial penalties on customers who choose to directly hire an employee of that agency. We believe that these penalties limit choice for individuals who are trying to make decisions about their long-term care. In 2019, the legislature passed Public Act 19-117 to address the problem of home care companies inhibiting free commerce in this area by prohibiting non-compete clauses in the industry. Now, instead of restricting employees from taking on other work, some of these companies are trying to shift this restriction and use financial penalties on the part of the customer. So House Bill 5332 is necessary to maintain the legislative purpose and clear intent that you established just 3 years ago. We are aware of at least one contract with a home care company that imposes a $10,000 penalty on customers who hire a home care aide that they've used through the company. Many individuals could never afford such penalties, and even if they could, we feel it's important that the legislation before you today offer the same vital protection to all Connecticut residents, regardless of income. This legislation also provides stronger protections for the employees of the agencies, ensuring that direct care workers who are in short supply, as we all know, have the economic advancement opportunities to grow and remain employed as caregivers, which is a crucial need for us here in Connecticut. As an agency charged with serving and advocating for both older adults and people with disabilities, we want to make sure that Connecticut residents are able to live as independently as possible in the community and in the setting of their choice. And we, like the legislature, want to make sure that people have the greatest amount of flexibility and freedom to stay in their own homes. And we want to prevent any actions on the part of home care companies that will interfere with that freedom. There are a number of other state agencies you just heard that support this bill. You heard from DSS, also the Office of Policy and Management, the Department of Consumer Protection, and the Office of the Long-Term Care Ombudsman. We do have some recommended changes to strengthen the language and protections of the bill by adding language that prohibits the company from other ways of charging the individual consumer, such as attorney fees, damages, or other legal intervention. The specific wording for those changes and the line numbers are outlined in the testimony, so I won't go through those now, but you can reference those. With that, I will conclude and thank you for the opportunity to offer this testimony. I look forward to continuing to work with you on this and other important matters as we go forward, and happy to answer any questions you may have.
Thank you, Commissioner. Thank you for your testimony. We really do appreciate it. And I think coming from you is so important because you have the oversight of the aging population as a commissioner of the Aging and Disabilities Agency. So thank you so much for your comments. Further questions or comments, colleagues? Seeing none, thank you, Wayne. Have a Commissioner, sorry. Have a great day.
Thank you. You too.
We will now go back to the public. And first up is Ann Wilson. Ann, you'll have 3 minutes, please.
Thank you. Madam Chair and distinguished members of the Human Services Committee, I thank you for giving me the opportunity to testify here before you today. I am here on behalf of Companions and Homemakers as the Client Services Manager and also as the daughter of aging parents who rely on agency services for their much needed care. I know over the course of the 30 years that we have been in business, we have, and along with our fellow agencies, we've enabled hundreds of thousands of Connecticut elder residents to age in place with dignity. I'm here today to talk in opposition of HB 3552. And I think there seems to be some confusion, at least on our part, and maybe on the part of the Home Care Association of Connecticut. Based on the language as we understood it in the proposed bill, it would not just umbrella the clients that we care for under the Medicaid or state services umbrella, but it would directly impact the clients and caregivers that we have agreements with privately. And that is truly our concern. I think there is a common misnomer. First and foremost, I would like to say shame on an agency that would put a $10,000 penalty in their contracts. I think looking at individual verbiage and individual languages and doing some research among the agencies would certainly be in order. Something like that absolutely should not exist. I know for our agency, the agreements that we have are very limited in duration. They don't prohibit choice. We support the self-directed care model. We support the allied model. We just want to maintain the choice for the elderly in Connecticut, for those who want to use an agency and have the benefits of the agency. Please keep in mind, we're providing workers' compensation. We're providing liability insurances. We're offering benefits for our caregivers. We're managing the care plan amongst the clients and the caregivers, ensuring that they get work and ensuring that the clients get the continuity of care they deserve. When somebody takes that relationship off the books, they lose those protections, and they also lose the consistency of potential work and coverage. Not to mention, if a client takes an aide from us to care for them, we lose the ability to place them on other clients. So there's a lot of concerns that come into play. And when I say limited in scope, the agreements that we have in place are for a very small window. They don't preclude somebody from ever taking a caregiver on privately. They just do so for a small period of time. In addition, our caregivers can work privately. They can work for multiple agencies. The choice exists. So I think what we're really asking today is, one, we don't want to see this pass, but two, more importantly, I think there's much more due diligence and much more information that has to go into consideration here before we broadly stroke a bill like this that impacts everybody and potentially causes catastrophic results for agencies here in Connecticut that have supported the state and our elderly so well after numerous years. Thank you.
Thank
Any
you for your
questions?
testimony. We do appreciate it. Quick question, Anne?
Yes.
How many employees have you lost since we enacted this 2 years ago so that employees could no longer be penalized? Because now all the agencies did was shift it to the clients. How many employees have you lost?
That would be something I don't have the answer off the top of my head, but certainly I could research that and get that information over to you.
Yeah, that'd be helpful. Thank you very much.
Absolutely.
Representative Nasser Francesco.
Thank you, Madam Chair. Thank you, Anne, for your testimony. Just really a quick question that's concerning is that I'm concerned that I'm a true believer in home care agencies, assisted living, and nursing homes, and that obviously those are private choices for people.
Sure.
Everybody has a unique situation that they need to be to take on those services.
Right.
But I'm concerned with something like this, that it's really going to have an effect on the home care agencies, and there's not
Absolutely.
going to be enough staffing for your agency. It's really, it seems to me, a deterrent to staff. And then with that, obviously that affects the clients and the families. What do you see as an effect on that? What could possibly happen with a piece of legislation like this passing?
Well, I think, between COVID and already the agreements that have been imposed on the caregiver side of things, we are seeing critical workforce shortages. So it makes it even more difficult for us to hire the staff that we need. And more importantly, in doing that, not only on the private side of things, but having the staffing and the resources to be able to support the home and community-based services that the state offers. I think, many agencies have been forced to discontinue because of funding and critical workforce shortages and a variety of different issues to discontinue taking on state clients or like for our agency, we had to look at the services that we were able to continue to provide so that we could continue to provide for the clients that we already have. It's going to create a staffing crisis, and it's going to allow no protection at all for the agencies in terms of the significant financial investments, time, training, hiring, benefits, compensation, all of the expenses that we have just to simply keep our doors open. And we have no protection for the clients, caregivers that we hire on board.
Thank you. Yeah, that's certainly obviously a concern of mine as well. And I'm just curious, in your business, do you see a request often that the client would like to just go outside of your agency and just hire the PCA independently? Has that happened often, or have you received any complaints or anything on that?
Well, I think that the better answer to that is that because people do have a choice, that they are choosing the agency model, and it has been a preferred model for a very long time. So people are doing their research. They know that they have different care options. So when they do sign an agreement with an agency, they have an explanation of what they're signing, and they understand the benefits that come along with bringing an agency on board. Right? It's different than saying, even if we were to operate as a temp agency, most temp agencies, if anybody's had to use them, if you hire on that temp worker, you have to pay a placement fee. So it's not so different. Yeah.
I agree. I think people make their choices, just like we were to hire somebody to do some type of service for us in our home, or whatever you choose to maybe go to a reputable business, because you reap all those benefits and you're secure that the work will be done correctly and you're going to get provided the best service. And I think those are good choices that people make.
Absolutely.
And thank you so much for your testimony. I am concerned about it. So I
And
appreciate
if I could just add one more thing, because I know
Sure.
this is a personal concern for me, is that, I fully support the self-directed model. And many people are in a position where they can effectively utilize that model. Maybe they're of sound mind. Maybe they have a spousal support system. Maybe they have family members, but just as many people are not in that position. So the scary aspect for me is when we don't have people with even these agreements taking pause before they make these rash decisions, thinking it's going to be benefit, what happens to the overall oversight of the care plan for those individuals when that client and caregiver are now taking that relationship off the books and there's nobody overseeing or managing that relationship, the quality, the potential for fraud, elder abuse, all of those things that agencies provide, especially as mandated reporters. So
Thank you. Just one real quick follow-up question. In your particular business, what percentage of your clients are Medicaid?
For us individually, about 40% of our clients.
40%.
Yeah. So we've been serving the Medicaid sector since 1990. So we know how important that business is, and we fully want to continue to support that. So it's not like we're in one end of the business or the other. We want to be there for elder care in general and in the best interest of everybody, the clients, the caregivers, the state, and certainly our agency.
Thank you very much, Anne. I appreciate your testimony today.
Thank you very much. And any further questions or comments? Seeing none, thank you very much for your testimony. We do appreciate it. We're now going to go back to our agency. And up next, Tammy, can you mute, please? Thank you. We're going to go back, and Mairead Panter, you're up next. Hi, Mairead.
Hello, good afternoon. Good afternoon, Senator Moore, Representative Abercrombie, Ranking Member Senator Berthel, Representative Case, and distinguished members of the Human Service Committee. My name is Mairead Panter, and I'd like to take the opportunity to offer you testimony today. I've written testimony and have submitted it, but I'd also like to speak to you regarding 3 bills. The first bill is SB 286, an act concerning deadlines for mandatory reporting of suspected elder abuse and penalties for failure to report. I support this bill and the added protections, including requiring mandated reporters to report elder abuse within 12 hours of such suspicion or believed action has transpired. Ensuring that appropriate authorities are notified will increase the ability to provide protections for individuals who may be at risk. I also believe it's necessary to have outreach, education, and accountability related to the reporting requirements. HB 5332, an act prohibiting home care agency contracts that penalize clients for directly hiring agency staff. This bill would prohibit home care agencies from applying financial penalties to individuals who choose to directly hire an employee that works for the agency. Current penalties in place negatively impact the clients who benefit from these services. Agencies' overall goals are to ensure that their business needs are met, and this can often result in the company moving staff around from one client to another. This has a significant impact on the client receiving care, yet the client has little to no control over what happens. Giving the clients the ability to hire staff directly without fear of being penalized would allow greater continuity of care and stability in the community. This type of stability can prevent future gaps, risk of decline, or potential need to go into a nursing home, unless that's their choice. Continuity and choice are important for people of all socioeconomic backgrounds, so I would encourage these protections be available to all citizens regardless of income. Staff working in these roles often welcome the stability and additional income afforded to them when a client offers to hire them privately. For example, my family and I personally deal with this when we try to fill hours needed for my brother to receive his individual goals. He has both agency and self-directed staff, but there's times when he's developed a bond with a staff member he would like to hire privately for other hours or to do things outside of their schedule. For example, he may want someone to drive him to my house for dinner or a niece or nephew's sporting event. However, that's not allowed if we want to avoid these financial penalties. This lack of choice has significant impact on his ability to fulfill some of his goals. I believe that there's many family members who would also like to supplement care in this way. For that reason, I strongly encourage you to pass this bill. Also, SB 290, an act concerning the certificate of need for long-term care facilities. I support this bill as it addresses the need for our long-term care continuum to be able to adjust, change, and adapt as there's changes in demand. I believe we need to be able to offer this ability and to oversee the right sizing of our nursing homes and make sure that it's done in a planned way so that individuals have choice and are able to receive high quality options related to their long-term care. We also don't want to see huge gaps in where care is provided and only have care in certain areas of the state. So thank you. That is my testimony today, and I'm available for any questions.
Thank you, Marie. Thank you for your testimony. We do appreciate it. Questions from colleagues. Representative Hughes?
Thank you. Thank you so much, Madam Chair. Thank you, Mairead, for your heroic service to the folks in our state. I just had a question about SB 286, the reporting of suspected abuse. We both work in this space of really trying to get families or observers or mandated reporters to do it. In terms of implementing it, I wanted your opinion about whether you think PSE, Protected Services for the Elderly, is appropriately staffed to increase that timeline from 72 hours to 12 hours in terms of receiving that call over the weekend. You know how many of these calls come in on Friday afternoon, or, you know, how do you see that playing out? And did we put, I know we didn't put anything in the language around increasing support and resources for PSE to deal with that, but your opinion on that.
Well, I've thought PSE needs support across the board for a long time, but related to this bill, the person reports, a person reports. The timeline changing on when they report, I don't think changes the responsiveness. So PSE is going to respond whether a person reports on Thursday or on Friday or Sunday versus Monday. The sooner you know that something potentially happened, the faster you're able to have interventions in place. And I believe that reduces the risk of exposure and further abuse happening during that window of time. So that's the reason why I feel so strongly about it, and that the more we can cut down on the risk of time between the incident happening and someone intervening, I think the better we'll be able to support the individual involved.
I agree. As somebody who answers the helpline, I get these calls often like at 5 o'clock. And one of the things that I do before I report to PSE is I try to call the municipal agent, or community, you know, maybe senior service director or something, just to see, because again, we're getting third-hand information. I'm not sure if I have a reliable report. So I try to verify that and then I make the report. And I'm just wondering, in terms of your experience with, I mean, you're in nursing homes, so obviously you're going to be reporting both to you and to PSE. That's our mandate, is if we see something going on in a nursing home, we're going to report to both of those entities simultaneously, right?
Well, actually, it shouldn't come to us simultaneously unless the resident wants it to. So on that, it says, have you told the individual if they're familiar with our agency and do they want it referred to us? And then absolutely we should receive that.
Yep.
But as far as in the community, it's suspected abuse, right? So that they have the opportunity to do that investigation and to get the information, and sometimes for people's recollection, when something happened, as close to the source and the time that they can get the information is when we have, I think, the best outcomes, and having that ability. And it goes back to the training. So for me, really ensuring that anyone working in this field or who would be a mandated reporter has access to that training and knows the expectation ahead of time.
Great. And did you submit any testimony around this and around supporting more resources for PSE?
Nope, I did not put that in my testimony, but like that, I do always support. This is a growing area.
Thank you.
And so yes, our bandwidth for all of our protections is small, but
Thank you. Thank you. Thank you, Maureen. Thank you, Madam Chair.
Thank you, Representative. Representative Master Francesco.
Thank you, Madam Chair. I promise not to drive you crazy today with questions, but it's our only opportunity. Thank you so much for your testimony and the work that you do. I really do think it's important, so I appreciate it. I'm just curious, you had mentioned in your testimony that people wanted to get on House Bill 5332, people would like to have a choice, maybe to hire someone after hours to help them do errands. Would you be able to give me how many complaints in a year or so and recently that you have received from clients of an agency that were unable to do that? Would you have a number by any chance?
I would not, and I could ask and see if there's a number out there related to that. For us, related to those complaints, if we're looking at individuals who live in like the subsidized assisted living who receive supports, I'm not sure we have the numbers related to that because it's not currently allowed. And so people wouldn't want to call and say they were doing something they weren't allowed to do or would put their relationship with their staff at risk. And so I don't know that we have a lot of actual data related to that. It's more related to conversation and people saying they're not able to do things and staff telling us they can't do things because they can't be hired in that way.
On top of mind, do you have that conversation often with people? Do you know?
It is, I would say it's a fairly frequent conversation when people look at how to meet those individualized goals and outside of their traditional plan of care, right? So there's a lot of things that I do in my day that aren't related to my activities of daily living, right?
Okay.
The things that I do because I have the ability to hop in my car to go and to do, and they're just not always able to do that. And we'd like to see people living as full of a life as an independent and autonomous as possible.
Of course. Okay, I just questioned that because it was in your testimony, so I'm assuming that the number was very high and it's a significant problem. But I was just wondering, when you go into the hospital, you have a different, every 8 hours or every 6 hours, you have a different staff. And obviously that happens in the home care industry as well. You're going to get different people coming in. Have you had any complaints or about people unable to change their agency that they're currently using because they were not happy? Was there any reason why somebody would not be able to do that?
Right now, the main area of concern we hear is just access in general, staff access in general, being able to switch agencies would be dependent on their area, their access to a provider, and if there's another provider in that area that is picking up individuals.
But they could choose. They do have a choice to switch agencies, right? Would you agree that they have a choice to do that if they were unhappy with the service? Oh, yeah. Okay. Well, thank you so much for your testimony today. I appreciate it.
No problem. Thank you very much.
Representative, we might be able to get you, Master Francesco. We might be able to get you some data from Consumer Protection. They were also involved with this bill. They were going to raise one there, and then they realized this was more of a human services bill, so we might be able to get you some data there.
Oh, that would be great, Representative. I would appreciate that.
Our pleasure. Any other questions or comments for Mairead? Seeing none, thank you very much for being here. We do appreciate it. We're now going to go back to the public. You have 3 minutes to testify. And Richard Bamegli, Eddie, I hope I said it right. You're up first.
You're close, Representative Abercrombie. Hi, thank you, and good afternoon now. My name is Richard Famiglietti. I live in East Haven, Connecticut, and I'm here on behalf of Senate Bill 283, an act to remove the income and asset limits for the MedConnect Medicaid for Employee Disabled program. I've been on this program for nearly 22 years now, and I was also involved with getting this this program passed and implemented so that people with disabilities can afford to go to work without losing their Medicaid benefits. This bill, this program is very generous. However, it still needs to be worked on. These income and asset limits kind of prevent me from improving my life saving for a nicer home, saving for a rainy day, saving enough for if I lost my job and I was in between jobs for a while, how am I going to pay my mortgage? I'll go through $10,000 in just a couple of months. All these kinds of things are preventing me from keeping my own safety net. What makes this worse is for non-working Husky C people, they're on this thing called a spend down. Back in 1985, when I got hurt, I was living on $900 a month. Well, correction, that was my income. I was on a $300 a month spend down, making me live on $600 a month. Let me ask you, when your medical expenses with your medical services and supplies are $2,000 a month, how are you going to budget your spend down for that? Well, let me tell you, I had to ask for bills. I had to have home care agencies bill me in advance so that I can pay them monthly. My credit was shot. We need to raise the income and asset limits for the non-working Husky C. When I am all done working or go back on disability and start collecting retirement, I'm going to be punished and go back on a spend down because of the low income and asset limits. This needs to be fixed. Thank you.
Thank you, Richard, for your testimony. Any questions or comments? Seeing none, thank you very much for your time, sir. We do appreciate it.
Show me the money.
Okay. Have a great day, sir.
You.
Up next is Representative Tammy Nuccio. Representative, hi.
Good afternoon. It is afternoon now. Thank you. Thank you for hearing me today. For the chairs Abercrombie and Moore, Ranking Member Case and Berthel, and members of the Human Services Committee. The House Republican Caucus would like to thank you for raising House Bill 5341, an act equalizing Medicaid rates for providers in inpatient mental health services in Eastern Connecticut. After 2 years of the COVID-19 pandemic, Connecticut has seen an unprecedented increase in mental health cases among its residents. Now that the pandemic has begun to ease, as a state, we must prioritize helping people who are suffering from mental illnesses like anxiety, depression, and trauma. An important part of our arsenal in fighting this crisis is an acute inpatient mental health care. We believe these services can make a big difference for many of our residents who need immediate and urgent help. Currently, hospitals that provide inpatient psychiatric and rehabilitation services are reimbursed through Husky on a per diem basis. 6 out of 7 of the reimbursable hospitals that reside in Eastern Connecticut are given the lowest per diem rates that are offered. The 7 Eastern Connecticut hospitals include the William W. Backus Hospital in Norwich, the Day Kimball Hospital in Putnam, Johnson Memorial Hospital in Stafford, Connecticut, Lawrence and Memorial Hospital in New London, Manchester Memorial Hospital in Manchester, Rockville General Hospital in Vernon, and Wyndham Hospital in Wyndham. The current distribution of Medicaid rates for these services is unfair and only hurts the patients. This proposal seeks to create a more equity between the Eastern Connecticut and the rest of the state and help all residents who have been suffering from acute mental health crises before and during this pandemic. A mental health emergency in Vernon, Connecticut looks no different than a mental health emergency in New Haven or Hartford, Connecticut. The cost of therapy, be it outpatient or inpatient, is no different in Stafford, Connecticut than it is in Torrington, Connecticut. It's time we start to recognize the cost of care regardless of geographical location. With this bill, we hope to ensure the residents of Eastern Connecticut have access to facilities that are reimbursed for care as equitably as those on the western side of our state. I've been listening to this hearing going back and forth this morning, and I heard Commissioner Griffins explain about the funding models and would ask at this point if we are seeing unintended consequences of our current tiering system or our modeling. Then we review those parameters and identify what is driving the differences so we can ensure that we have the ability to offer equal services in the state to all of our residents. The House Republican Caucus is grateful to the Human Services Committee for the opportunity to testify on this important issue today. However, we want to make it clear that this bill does not and should not include Natchog Hospital, as it is not, I believe that is in Mansfield. It is not an acute inpatient hospital facility. I urge the committee to pass House Bill 5341 and to give the residents of Eastern Connecticut equitable access to much needed inpatient mental health services.
Thank you, Representative. We appreciate your testimony. Questions or comments?
Holy moly. The lights just went off in the conference room.
Well, that's okay. We don't have any questions or comments, so we'll give you the opportunity to fix your camera. Thank you for being here today. We do appreciate it.
Thank you.
We will now go back to the public. You have 3 minutes, and next up is Kelly Green.
She's muted.
Kelly, you're on mute.
My apologies. Thank you, Madam Chair and distinguished members, for allowing my testimony this afternoon. I am testifying this afternoon on behalf of the HCAOA, and I am also the Chief Operating Officer at Visiting Angels. I am testifying in opposition of the House Bill 5332. And I am echoing a lot of the testimony that you've heard already this afternoon. But I would like to spend a little time and just talk about the importance of the matchmaking that we do, so that you could really understand the work that we do when we match a caregiver to a client, and the services that a client hires us to do. They make a choice. We're not taking away a choice in what someone can go to other avenues to hire caregivers on Craigslist or through a friend of a friend. They come to us to hire us for a service. And we spend a lot of time getting to know our caregivers and our clients. And searching for the right person means everything. And we spend a lot of time and resources and energy in finding the right temperament and whether or not they're going to be the right fit personality-wise, whether or not they're COVID vaccinated, whether or not they drive, whether or not they're going to have the availability. And sometimes we make it, we do a right fit the first time, but sometimes it takes several trials and errors of caregivers to find that perfect fit. And, it's very labor intensive with care managers, with, office staff. To the idea of making that match, spending all of that time to do so, and then having the family member to say, okay, well, thank you very much for making that match and doing all of the work for us, onboarding this caregiver, vetting them, doing the background checks, and then saying, okay, well, I'm just going to take them off your hands now and hire them privately. It's really kind of absurd. It angers me, really, quite frankly. People have a choice. They don't have to come to an agency to do that. But they choose to do so. Not only is it so important about what we do with making the match, we protect our caregivers. We are an advocate and a liaison between the families and the caregivers. When a caregiver is hired privately, there's no protection for that caregiver. Caregivers come to us when they have a problem, and then we act as a liaison between our caregivers and the families. I fear when people are, hired privately, those clients have no supervision. There is a greater risk for neglect, for abuse, financial abuse, for theft. For clients who cannot advocate for themselves, they cannot report when a caregiver doesn't show up. Through our protocols of timekeeping, we know when a caregiver doesn't arrive. We can ensure that someone's there. Someone had talked earlier about, changing in caregivers, sending different people. That's part of what we do. If a caregiver gets sick, has an emergency, needs to take time off, the agency, we're there to make sure that that client has care and they're not put at risk by being alone. When someone is
Excuse me, your 3 minutes is up. If you'd like to summarize, please. Thank you.
Yes, thank you so much. I appreciate the opportunity for being heard, and I'm happy to answer any questions.
Thank you, Kelly. Representative Master-Francesca.
Thank you, Madam Chair. Appreciate it. Thank you, Kelly, so much for your testimony today. I appreciate it. Just a couple quick questions. In the home care agency, model, what is the turnover rate on your PCAs?
I don't have a percentage in turnover rate. I can tell you that I really couldn't give you an answer. But I know that, for some, it's hit or miss. That, sometimes a caregiver will say, I don't really like this client because of their daughter, and I want to be removed. Or the client might say, this caregiver has too thick of an accent. You need to replace them. So there's turnover for so many different reasons. And that's where our work comes in, where we're constantly working to make sure that that person has the right match for a caregiver. So the turnover it can be continuous.
And I get it. I'm sure that was a broad question. I know when I used to work in assisted living, depending on the time of the year it was, there was always a larger turnover. I was just curious if you knew that. So should this bill pass, I mean, obviously I'm assuming there's a shortage right now of PCAs.
Tremendous shortage.
Percentage of PCAs that have been lost since COVID, would you have any idea on that number?
I'm sorry, I could not answer
Okay, that's
that
okay.
calculated percentage, but I can tell you, working through the pandemic, we've seen a tremendous loss of caregivers, people who, were affected by childcare issues when schools were shut down, caregivers who, were affected by, not wanting to work, not wanting to expose themselves. And then, by getting those, bonuses and for the unemployment, those economic stipends, and then just never returning back to work. I don't think that we have even fully recovered, even from last September when those stipends had stopped, the unemployment stipends. We've not really fully recovered from that yet, like we would hope we would.
Yeah, and I'm sure the cost to train people, staff them, constantly keeping up on that, and then you lost a lot, I'm sure, during the pandemic, and now you have to start that process again. So I'm assuming those costs are pretty significant.
Yeah, the average cost to train and onboard, these figures were forwarded to me, are about $2,000 for onboarding and training a caregiver. And the annual cost to manage, schedule, supervise a caregiver is about $6,600 a year per caregiver.
Is that $6,600 plus the $2,000?
Correct.
So it's about
So
$8,000.
onboarding and training a new caregiver, doing background checks, onboarding them, training them is about $2,000 per caregiver. And then the annual cost just to manage them, schedule them, supervise them is about $6,600 per caregiver.
Wow. And then one more question on the penalty. The previous speaker was mentioning, and this number was thrown out today, that some contracts for home care agencies to their clients are given $5,000 and $10,000 penalty, which is outrageous, obviously. Is that number accurate in your experience? Is that an average that they're charging?
I couldn't say for other, for other agencies. I know that it's customary to have a penalty, for clients in their contract to say, if you hire our caregivers privately, there will be a penalty. And it's meant to be a deterrent to say that we are going to do the work for you. We are going to match you with a wonderful caregiver, that we're going to try to meet all of the criteria that you're looking for, that you can call us when you don't like a caregiver, if you don't like the way that they are cooking your food, if you can't understand them, we're going to do these things for you. But when we finally make that match for you, if you try to hire them privately, there will be a penalty. And that's a standard clause in contracts.
Well, and that's what was my argument. It is a private contract between the agency and the client, that they clearly have a choice to enter into or not. So I certainly understand that. I don't have any further questions, but thank you so much for your testimony today. I appreciate it, Kelly.
Thank you.
Kelly, just a quick follow-up. How much did you say your penalty is?
I don't know exactly. I'm sorry.
Okay, and then just to add to that conversation, Non-compete clause are not common in the human services fields. Home care is the only area that does a non-compete clause, just for clarification.
No, I
Um,
just meant in home care. Again, once
Just
we are
in home care, correct.
when we are making the match and making the significant investment in our caregivers, in our workforce, for making sure that we're providing the best caregiver for you, that should you choose to try to take our caregiver away and hire them privately, there's a penalty. And if you choose to engage in business with us, you're agreeing to accept that penalty.
Right, and we as a state believe in home care and the work that you do. We thank you for it, but we also believe that people, consumers, have the right to choose. And this is about choice. And this is also about a penalty on a family of up to $10,000 for deciding to switch home care individuals. So let's just be clear on what we're talking about here. And we're talking about low wage workers also. What do you pay? What's the salary of an average home care person that you hire?
$14 to $18 an hour.
Exactly.
Respectfully, they have a choice. Should they not be happy with our services, they have the choice to go to another agency, to go to Craigslist to hire someone privately. They have a choice to make all of those changes or decisions. There just would be a penalty if they want to use our caregiver in which we made the investment to match them with.
That's right, but it goes back to consumer choice. You're absolutely right. I think we're saying the same thing. Thank you. Senator Moore.
Well, Representative Abercrombie, you asked my two questions, and one was about wages, and the other was about consumers having a right, having some say in leaving. And I think that penalty, when you consider about who we're talking about, and many of them have limited income, when you start talking about that amount of money, I wonder, where's the compassion for the person? Also, I mean, we have to protect the consumer the same as a business. So that is some of my concern about, my concern is really the salary and the ability of the consumer to be able to choose who they would like to have also. And I know during COVID, so many ills were highlighted, but we also know how much we were dependent upon your services to take care of so many people. And I appreciate that, but I try to do a little bit of a balance here to make sure that the people who are doing this work are paid more than a living wage, but paid for the work that they do and how dependent we are upon them, not only in a crisis, but I think every single day to do that work. So thank you for your testimony. And thank you, Representative Abercrombie. And get out of my head.
Sorry. Great minds think alike. That's all I can say. Representative Dathan.
Thank you very much, Madam Chair, and thank you, Kelly, for your testimony today. I heard a lot of the questions that I was thinking about from both Representative Master Francesco as well as from Representative Abercrombie, but wanted a quick question on the tail of the payment that has to be made. In your contract, you weren't 100% sure about the value of this payment. Is it based on the amount of wages over a certain period of time for the individual? And then what is the tail on that?
I would have to look at the contract to get the exact language, which I can get that information for you.
In terms of the time period then for the tail, do you have any idea about what the time period is? So once a consumer stops working with your agency, what is the time period until if they decide to hire their caregiver? Do they have to wait 30 days or 15 days, or how does that work?
I don't believe there is such language as that in my contract, but I would have to again look at it closely before I commented that to you. I apologize.
Okay, because it seems like
I'm newer to my company. So again, I'm just not as versed
Yeah. So, generally, like in the business world, you would see these sort of non-poaching agreements only for sort of mid-level to executive level salaries. You rarely see this for an entry-level minimum wage worker. And so that's really my concern. And then, I also have a lot of concerns for the consumers and to say, hey, we need to, one of your customers, your clients, their needs change. And instead of getting, the person maybe, let's say 5 hours a week, they need, 30 hours a week because the individual's needs change. But that customer wants to have, continuous care from their provider that they've built a relationship with. But if that provider is working with multiple clients, they're getting pulled in a lot of directions. And I just have a lot of concerns about that, the contracts don't sound like they're very flexible for the workers, especially if you're considering what the time is. I also, without knowing the full tail on these agreements, if they're, how long this non-poaching clause takes effect, it's really hard to kind of get an understanding what the issues might be. So,
well, I think that all agencies' contracts from experience are different. The language is different for all agencies.
Right.
As far as what the penalties might be for the length of time that someone can hire them, after leaving the organization. I didn't quite understand what your question was about, from if someone wanted to extend their hours and the caregiver not being available.
Right. So if you have a full-time worker who works on, let's say, 5 different patients or recipients, and all of their families that they're working for, like this person, want the hours, but one of the recipients needs to up their hours, and so they want to have that continuous care from their provider, and employing that person directly would ensure that they would be able to do that. So it's ensuring the best continuous care for the individual.
So as a manager, what we are always looking to do the best thing for the client and the caregiver. So looking at what the best hours is going to be for the caregiver and for that client. And the caregiver always has a choice in accepting or not accepting a client. So
right.
When we call and offer an assignment to a caregiver, they always ultimately have the choice in whether or not they accept it or not. So if there were 2 assignments for Mrs. Jones and Mrs. Smith, and Mrs. Smith was 30 hours and Mr. Jones was 40 hours, they can choose which one they want. Again, so it's not only making the clients happy, we make the caregivers happy. So we offer the caregivers choices as well. So again, as an agency, we are looking out for both parties, for the caregivers and the clients.
Yeah.
So for instance, also if the client goes to the hospital, we are then able to offer that caregiver another job elsewhere, either on an interim basis for fill-ins. And then also, if that client passes away or moves or no longer needs our service because it was only a short-term assignment, we then are giving them more work. We are then placing them with other families. So we're looking out for the best interests of both our clients and our caregivers.
Okay. For your caregivers, are they employees or are they 1099?
They are employees.
Okay. And as part of their employment agreement with you all, do they have to sign a non-compete to be able to go work at another agency?
No. They are free to work at as many agencies as they choose, and most of them do. You know, we call them often and they say, I can't work with you this week because I'm working with X agency this week. They have the opportunity to work wherever they choose.
So do they also have the ability to work privately and not necessarily
Absolutely.
for your agency?
Absolutely.
Any restrictions in their agreements that say that they can't work for any former
no
use of yours?
No, and they
So
can work, they can take a job from Craigslist to work for Mrs. Susie Jones down the street, Monday through Friday, and many of them do. And then they supplement their hours with us working on overnight shifts. The only difference is that this language would prohibit a client from hiring an existing caregiver that we have matched with them, that we have invested our resources in making that match with them.
So if the client terminates their arrangement with you and the caregiver terminates their employment with you, is there any liability on either the caregiver or the former client to pay you if they have start a new relationship and start working privately together?
This language in our contracts would then it would impose a penalty to the client, not to the caregiver, to the client, former client, because now what they essentially have done is engage our business to hire us to make a match with them. And, you know, I went into great detail of what that is involved, you know, hiring, onboarding, vetting caregivers, the time to match them. And then, okay, I'm done with my contract with you. They engage the caregiver and say, I'm going to pay you X amount of dollars, quit your job with, you know, your agency, come work with me. So, you know, now we've lost our business and our caregivers, our investments.
Yeah, but you're not sure what the tail is on that. Once the client terminates the relationship, how long they have. So that's probably the only question I have, because just trying to get a better understanding. But I think, you know, my overarching thing is, you know, you see these sort of non-poaching arrangements for, you know, more senior staff, not entry level and lower paid workers. And that's my concern. So thank you so much, Madam Chairs. I appreciate you giving me the indulgence here. And thank you, Kelly, for your testimony today.
Thank you.
Thank you, Representative. And just for clarification, for the line of questioning that you were asking, the agencies were doing non-compete clauses in their contracts with their employees. We legislated 2 years ago for them not to be allowed to do that. And now they've shifted from the employees to the clients. And that's what we're trying to get away from, our non-compete clauses overall. So let's just be clear, everyone that's on this Zoom, what we're talking about here. So just so that you understand, they did try to do it with employees.
Thanks for clarifying that, because I remember that a few years ago and I was trying to remind myself. So thank you very much.
You're absolutely right. You're absolutely right. Thank you, Ms. Green. Have a great day. Up next is the Honorable Beverly Straight Kafalis. I hope I said it right, Your Honor.
You did pretty good. You did pretty good. I'm Judge Beverly Straight Kafalis, the Probate Court Administrator. Good afternoon, Senator Moore, Representative Abercrombie, Senator Berthel, I'm not sure is on the meeting at the moment, and Representative Case, and honorable members of the Human Services Committee. Thank you for the opportunity to testify this afternoon regarding Senate Bill 199, an act concerning the opening or setting aside of a parentage judgment. The probate court system takes no position on Section 1 of the proposed bill as it relates to superior court proceedings on a claim for parentage. And we do support uniform standards to open or set aside parentage orders. However, I have to oppose Section 2 of the bill, largely based on technical challenges with the language. In particular, the proposed bill would conflict with two statutory provisions and result in legal inconsistencies and confusion. Although we support limiting when a parentage order may be opened or set aside, and that an analysis of the best interest of the child should be a requisite standard of review, as I indicated, the language as presented does conflict with two other statutory provisions. It's also important to note the distinction on the claims for parentage filed in the Superior Court and those filed in the probate court. In particular, in the former, in the Superior Court, it is the birth parent who is seeking a parentage determination as to an alleged genetic parent. In those cases, the alleged genetic parent is the defendant or the respondent. Conversely, in the probate court, it is the alleged genetic parent who is asserting they are the parent, and by their claim as provided in section 46B 172A subsection A, the alleged genetic parent is stopped or prevented legally from denying parentage in any action under section 46B 160. And the petition itself includes an acknowledgement by that claimed parent of liability for the support of the minor child. The proposed language creates a conflict between subsection A by saying, on the one hand, the claimant is stopped from denying parentage, but on the other hand, allowing the same claimant to seek to open or set aside the determination within 4 months. It's confusing at best and a legal conflict at worst. Secondly, the provisions of Section 2 conflict with Connecticut General Statute Section 45A-128 that already provides a mechanism in the probate court proceedings for a party to seek reconsideration, modification, or revocation of a probate court order or decree. Not only does Section 45A-128 delineate the limited circumstances to take a second look or have a second bite at the apple at an otherwise final order or decree, the time frame is slightly different in that it must be filed within 120 days as opposed to the 4-month language set forth in Senate Bill 199. I don't think that these are insurmountable technical challenges, but certainly the proposal as drafted would have legal inconsistencies and conflicts that I would be happy to work with the committee to resolve. And I'm happy to answer any questions you may have right now.
Thank you, Your Honor. I think I'm going to ask you, what would your recommendations be to make this work?
Well, I think one of the distinctions, as I shared, is that in the Superior Court, because it's the birth parent or the mother who's seeking to adjudicate a father as legally responsible, but in the probate court, it's actually the alleged father who's asserting parentage. So I think clarifying language would limit reopening or setting aside such a parentage order by the birth parent, who in the probate court is the one who's responding or defending. It's inconsistent with a parent who's the alleged genetic parent to, on the one hand, assert the parent and then have a second chance 4 months later or within 4 months to set it aside. So the language should just be limited in the probate court proceeding to clarify that it's the respondent or the birth parent who should have that opportunity to open or set aside based on the limited language already in the proposed bill. The other aspect of it is that we would have to reconcile 45A-128, and it may be appropriate to add language in that statute that those circumstances to reconsider, modify, or revoke a probate court order exclude those orders as to a claim for parentage. But I think there might be other ways to reconcile the discrepancies.
Well, thank you, Your Honor, and thank you for your testimony and coming here today. Our attorneys will be in touch with you, as
Thank you.
will my co-chair, Representative Abercrombie, to see how we can make this work. Thank you. Are there any
Thank you. Look
questions?
forward to it.
Seeing none, I want to just thank you again.
Thank you. Have a great afternoon,
You
everyone.
also. Next, I believe, is Karen Healy.
Hello, can you guys hear me?
I can hear you and I can see you.
Hi, Senator
Hi.
Moore. Good afternoon, Senator Moore, Representative Avery. I can't say it, but it's okay. Distinguished members of the Human Services Committee. My name is Karen Healy. I'm a registered voter in Hartford and a person recovering from mental health and physical health conditions. I've been living successfully in the community for 7 years. Before this, I spent 24 and a half years living in inpatient psychiatric hospitals. Hold on. Between Hudson River State Hospital in Poughkeepsie, New York, and Connecticut Valley Hospital in Middletown. I'm here to testify in support of SB 283, an act eliminating income asset limits for Medicaid Connect program and persons with disabilities. I would like to work so that I can contribute to my expenses and qualify for MedConnect. Eliminating the income asset limits to MedConnect will help people like me who want to be able to work but do not want these limits to prevent them from growing financially and saving for emergencies, considering all the living expenses and how costly unexpected emergencies can be. For example, I've been not considered working disabled now since October of last year because I had a job and I don't now still. So right now I'm at the point where I have Medicare A and B and I had Husky C. And that's on hold. Right now, I found out I need 2 major surgeries on my left side. I need a total left hip and a total left knee. So that's kind of holding up the process because Medicare only pays for a certain amount. Like the nursing and rehab and physical therapy would have to come out of pocket. So that's what I want to use as an example. But even when I get a job, I get MedConnect coverage. What will happen when I no longer are able to work? The current income asset limits for Husky C are so low that make it difficult for me to keep my coverage and force me on a spend down. Like right now, I'm on a $5,000 spend down, which has been difficult for me to meet. Because of this, my Husky C is on hold until I can find a job. I have been searching very hard for the past few months, but getting a job isn't easy because of my limitations. Until then, all I have is Medicare, which doesn't cover my nursing, rehab, or physical therapy, and other important health care Husky C or MedConnect would cover. Because of this, I've had to pay out of pocket, which adds up to my difficult for my money to afford. I don't want to work. I do want to work hard and save up just as the struggle to keep Husky C coverage. When I'm no longer able to work, please also raise the income asset limits for Husky C, which would be give me some people more breath. I really appreciate you listening to my testimony and thank you for letting me share how my important Husky C and MedConnect coverage are to me. Thank you. Is there any questions?
Thank you for that testimony, Karen. Appreciate it. I'm looking to see. I don't see any questions for you.
All right. Thank you for having me. I appreciate it. Thank you.
You're welcome. Thank you, dear.
Bye.
It's on 5. Good job.
That's okay. Next is Sheldon Taubman.
Good afternoon, Senator Moore, Representative Abercrombie, and other distinguished members of the committee. My name is Sheldon Taubman. I'm the litigation attorney at Disability Rights Connecticut. We are the protection and advocacy system for Connecticut, serving individuals with a full range of disabilities. I'm here to testify about the impact of 3 bills, SB 283, 288, and HB 5333 on people with disabilities. MedConnect is a very important health insurance program for people with severe disabilities who are able to work. The income limit is set at $75,000 a year, which is about 555% of the federal poverty level. It has asset limits of $10,000, $15,000 for a couple. But these asset limits present an obstacle, as you've already heard by the last witness and Rick Famiglietti. It makes it very difficult for people to save for the future. Others will explain passionately about this later. Removing the income and asset limits will benefit some working people with disabilities who then will be able to access critical Medicaid benefits, such as the last witness is not able to access. But I would also like to talk about what is not in the bill, and that is any relief at all for people who are on Husky C, the Medicaid program for people who are over 65 or older, or who are disabled under the same disability standard as MedConnect, but are not able to work. So yes, it has an extremely low income limit. Husky C is set at $941 a month in most parts of the state. That's about 84% of the federal poverty level. So to compare all the other Medicaid programs besides MedConnect, 550% of federal poverty level, Husky A adults 160%, Husky D 138%, Medicaid waivers 223%, and Husky A and D have no asset limits at all. The unfairness of this is seen in disabled individuals who were on MedConnect and who then lost their ability to work, as we just heard, and they lose their MedConnect with the higher income limits. They then go down from $75,000 to, as I said, about $941, or even the highest in Fairfield County, $1,052 a month. That's about a 1/7. You go down to 1/7 of the income limit, and your asset limits go down from 10,000 to 1,600. Again, about 1/7. There's no obstacle to Connecticut raising the effective limit for Husky C in terms of federal law to match the lowest income level, say, which is 138% of poverty for Husky D. This can be done simply by increasing disregards. California now sets it at 138% of poverty for the age blind disabled population. I'd be happy to talk with your lawyers about how to do this technically. And if there's questions about why there's specific language in what advocates are talking about as additional language for this bill, it's attached to Kathy Flaherty's testimony, by the way. I'd be happy to explain that if you have any questions as well. Besides 283, I want to talk briefly about 288. This bill would completely exempt DSS from having to go through any notice or public hearing regarding any new, renewed, or altered Medicaid waivers or state plan amendments during a public health emergency declared by the state or federal governments. And basically, this is a real concern. I realized that there was an emergency and it was appropriate that certain things were not done pursuant to state law. And in fact, the governor simply, modified the statute so there's no need to comply through, I believe, April of 21. But people with disabilities, particularly those covered under the many 1915 waivers for community-based services, could be negatively affected by the carte blanche authority in this bill for a future administration to disregard all these public transparency rules, such as by tightening eligibility, reducing benefits, and there be no opportunity for public notice or comment, simply on the say-so of the government. And lastly, HB 5333 concerning the PACE program. It's not often stated that PACE is a capitated program. That is to say, all the money from Medicare, Medicaid goes into fixed payments per member per month, and then the provider, has the financial incentive to skimp on care. This was already statutorily authorized as a pilot over 2 decades ago, but it was not piloted. If a demonstration were first actually implemented
sorry,
by
your
DSS,
3 minutes is up. If you could please summarize.
Oh, sure. Yes, just finish.
Thank you.
Thank you. So if there were a demonstration as already authorized in the law, implemented by DSS, then we could see the impact on people with disabilities. But in the absence of a successful demonstration of this concept in Connecticut, people with disabilities who are on both Medicare and Medicaid will be put at significant risk from adopting this capitated option as a state plan amendment. So there's real concerns there. Thank you very much. Happy to answer any questions.
Thank you for your testimony, Mr. Tubman. Representative Abercrombie.
Thank you, Madam Chair. Good afternoon, Sheldon. Thank you for being here. It's always great to hear from you. Just a quick question. So on the MedConnect, is everyone that's on MedConnect on Husky C?
I think technically I don't want to answer for sure. DSS knows the answer. I think technically it's not considered Husky C. It's a different program. Yeah. But they're both what's called non-Magi programs, but yeah.
So what I'm hearing for testimony today, and correct me if I'm wrong, because I'm sure you've been listening, is that people that are testifying are not testifying so much on the MedConnect legislation. What they're saying is, if we're going to do anything, what we should be doing is removing the asset limits for Husky C, so that more individuals will be able to get on Husky C, because the MedConnect doesn't cover everything that Husky C covers. Is that kind of what you were hearing?
Well, first of all, unfortunately, I didn't hear all the witnesses before, so that's a little bit of a
Okay.
disadvantage. But I
right.
don't, part of that I don't think is correct. MedConnect is a great program. It covers,
Oh, I agree.
once you're on it, you get all the Medicaid benefits. The problem is that if you're, it's really, there's no complaint about the benefits of MedConnect other than people on it saying, you know, like Rick from Miglietti says, you know, I can't really save because there's a $10,000 asset limit. There's a $75,000 income limit. So folks are testifying in basically the coverage is good, but they're saying the eligibility should be improved. Okay. That's what I understand the testimony to be. And that would benefit some people with disabilities who are able to work. But other people are also saying, and they're not inconsistent. I think most people are testifying in support of both, is what I'm hearing. And Husky C, however, has way, way lower income and assets, like 1/7, as I said. And you know, it's far lower than Husky D, any of the other programs. It's really puts people in a terrible spot. And the way you're seeing it is that the witness before me and Rick Famiglietti talking about in the future when he's no longer working, what he's saying is, if I can't work anymore, even if you don't change MedConnect, I'm not going to be able to stay on Medicaid because I'm not working, but my income from Social Security disability presumably is too high, and therefore I can't be on Medicaid at all. I can be on Husky C through spend down, but I can't afford to do that. And so the result is that when I lose the ability to work, and I lose those much higher income and asset limits, I now lose all Medicaid except on spend down, which is impractical, which means I lose all Medicaid. And even those who have Medicare, you know, some of the folks we're talking about do have Medicare. I think it was testified earlier what's not covered by that, all kinds of stuff. So having Medicare is great, but you know, you're really limited and you're in a really bad spot. And it's out of pocket, could be thousands of dollars for dental or home health services or whatever. I mean, I don't want to speak for other people, but I think that's what I'm hearing. And I think there's witnesses after me who have written testimony, so I've looked at it. And I think in general, people are testifying both in terms of improving MedConnect in terms of income and assets, and for people who can't work, Husky C, also doing something significantly for that group, which has really been disregarded for so long and has by far the worst eligibility standards.
So people that are on MedConnect can have income up to 75,000. I've heard both. I'm not sure exactly what it is, but the requirement is that they have to work, right? So individuals that are on there they don't qualify for MSP or any other programs because their income is too high, correct?
Did you say MSP, Medicare Savings Program? Medicare Savings Program has higher income limits. So you do have people, and the answer to your question, it's exactly 75,000 a year. Yeah. But the Medicare Savings Program has higher income limits. So that's, I believe QMB is to 11% of poverty, and then it goes up. So they could be on MSP, but MSP, all that covers is the cost sharing under Medicare and doesn't help you with the things that Medicare doesn't cover at all, you know, like the dental, the hearing aids, vision, home health aids, non-emergency medical transportation. Medicare Savings Program doesn't touch that. It just covers the cost sharing within Medicare.
Right. Okay. Thank you, Madam Chair. Thank you, Sheldon.
Thank you.
Are there any other questions? Thank you so much, Mr. Drummond. Next up is Allison Weir.
Good afternoon, Senator Moore, Representative Abercrombie, Senator Berthel, and Representative Case. My name is Allison Weir. I'm with Greater Hartford Legal Aid. I'm a policy advocate, and I'm here on behalf of the Connecticut Legal Services Programs. I've submitted written testimony that's fairly lengthy, so I won't read it here, but I just wanted to highlight a few things. First, Legal Services supports SB 192, which will which restructures the sanctions against the temporary family assistance program to better target the family member who's non-compliant rather than penalizing the entire family. We also support the provisions that will streamline the processing of TFA applications, and in that same spirit, we support SB 193, which makes it opens up the pool of people who can administer oaths. We support, and to amplify on Sheldon's testimony, we support SB 283 to remove the asset limits and income limits on the MedConnect program for Husky coverage for disabled workers to remove disincentives to disabled workers to really progress in their career as much as possible. But we urge the committee to look at Husky C generally because it's two sides of the same coin. The folks who are working now, the disabled folks who are working now, will one day not be able to work. And they'll still be disabled and they'll still need the Medicaid, the wraparound services that Medicaid provides that Medicare does not. So they'll basically have to erase all the gains they've made, any savings they might have had to be able to get on Medicaid onto Husky C. Husky C's income eligibilities are tied not to the federal poverty level, but to the temporary family assistance standard of need, which is only infrequently updated, so it doesn't keep up with the inflation. So what happens is every year, fewer and fewer people in poverty qualify for Husky C, or for that matter, for temporary family assistance, despite the fact that people still need these. So as long as we're talking about TFA, we support SB 285, but we also urge the committee to take a look at changing the eligibility standards, something based on federal poverty level. We it's been noted by the committee many times that we keep lapsing funds for TFA. And that's not because the program's succeeding, it's because the program's failing. Fewer and fewer people in poverty are able to qualify for this program because we don't lower the eligibility, but we never raise it to go along with inflation. So we really need to look at these programs, get rid of the standard of need eligibility, which has nothing to do with the federal poverty level, so that people who need these programs can actually get them. Currently, only 27% of families in poverty in Connecticut get TFA. That's not a successful program. So we support these programs. We ask you to take a look at all of the bills and to the extent, make them work better. So I thank you for the opportunity to testify, and I'm willing to take any questions.
Thank you, Allison. It's interesting. We had a meeting earlier that talked about the funds that get sent back because of not being used. And I think you made a good point when you mentioned the programs need to be better and stronger. So thank you. Representative Abercrombie.
Thank you, Madam Chair. Allison, just a quick question.
Sure.
So if we had extra dollars to do something, right? And listen, I'm appropriations. I'm not telling anybody that we've got all this money out there. But if we had some dollars to do something, would it be to invest in the Med Connect and change that program? Or should we take the limited dollars we have and change the eligibility requirements for Husky C? Because I don't think we can do both. So I'm just trying to figure out with the limited dollars we have, which way would be the best way for us to go.
So I'm going to preface this by saying that first, legal services work with low income folks. So we're more apt to working with Husky C enrollees than Med Connect. That said, I've dealt with a lot of Husky C would-be enrollees who are on disability, so they're not making much money at all, but they can't afford to spend down to get into actually Husky C. I've also dealt with families who, because of the asset limits, they're currently paying for homemade, out of their pocket, but and they've applied for Husky C, but they're waiting for to get on the program. So they're in the awkward position of not having enough money in their bank account to pay for the homemade for that month, and yet still having too much money to be eligible for Husky C.
Yeah, I get what you're saying. Absolutely. I think the challenge is, right, with limited funds. My understanding is, according to the commission, there's only about 615 people on Med Connect, yet there's about 4,400 people on Husky C. So,
and every year we have fewer people on Husky C because they don't meet the eligible limits.
It's so low. Okay. Thank you. Thank you, Madam Chair.
Thank you. Are there any other questions? Seeing none, thank you for your testimony.
Thank you. Have a good afternoon.
Next is Andrew Banoff.
Good afternoon, Senator Moore, Representative Abercrombie, and members of the committee. It's a pleasure to be with you. And first and foremost, thank you for all your work on so many important issues. We appreciate it. As you know, I represent Jewish Senior Services, which has been a nursing home for nearly 50 years and a proud nonprofit organization serving the community. We have long worked to support the state's goals of bringing people care in the community, not just in the institution. And today I'm here to talk in support of House Bill 5333, a program of all-inclusive care for the elderly. In my written testimony, I gave you a little bit more detail and also some attachments from the association, but just want to really emphasize a couple of quick points. PACE is a fabulous program that has been introduced throughout much of our country. It is designed for dual eligible seniors, those receiving both Medicare and Medicaid benefits, to receive a coordinated delivery of care. Our state started the process of introducing PACE about 20 years ago, and this bill will enable us to move that forward. Certainly, many members of the nonprofit association Leading Age are interested, including Jewish Senior Services. We think it's a way to better coordinate care. It helps people remain out of the nursing home and receive care in their homes, in the communities, which, as we all know, is where they want to be. It's consistent with the state's long-term care plan. And just to reference a couple of quick facts for the record, there are 144 PACE programs that operate nearly 300 sites and serve 58,000 individuals in 30 other states, including both our neighbors to the east and north. It is a well-respected, well-regarded, well-overseen program that enables people to do better by coordinating care, and we are very interested in seeing this move forward. I'm very pleased to be here in support of this bill and happy to answer any questions.
Thank you. I had the privilege of going over this PACE program with someone from your staff and talked about it, and I understand this would be the first time in Connecticut that it would be implemented, correct?
That is correct, Senator Moore. There is a bill on the books from a number of years ago. We need the enabling legislation for this to move forward. And clearly there's work to be done with the Department of Social Services and obviously with the legislature to make sure we provide all the proper protections for those that we all want to serve as best we can. But this is something that would be new for Connecticut.
All right. Are there any questions? Thank you so much, my neighbor. Good to see you.
Good to see you as well, Senator Moore. Thank you all. Have a great day.
Next is Tracy Wadette.
Thank you, Senator Moore, Representative Abercrombie, and distinguished members of the Human Services Committee. My name is Tracy Wodak, President and CEO of the Connecticut Association for Healthcare at Home. I am also an RN with nearly 40 years experience. The Connecticut Association for Healthcare at Home is the united voice for our licensed home health and hospice agencies, as well as several non-medical homemaker companion agencies. Together, our members provide services that foster cost-effective home care for Connecticut's Medicaid population in the setting they prefer most, their own homes. I'm testifying before you today to oppose HB 5332, an act prohibiting home care agency contracts that penalize clients for directly hiring agency staff. As you've heard from many testifiers over the past few weeks, healthcare workforce is in a crisis. The severe shortage in staffing, combined with an ever-growing aging population with a strong preference to age in place at home, equates to greater needs for workforce. Agencies are doing all they can to retain their current staff. That's why this bill is a difficult and sensitive one. Agencies can't afford to lose their staff that they fight so hard to keep. A key component of successful supportive in-home care is the hiring, including thorough background checks, orientation, ongoing training of staff to ensure that the client's individual needs are addressed and agency policies are followed. Agencies are also required to comply with labor laws, adding additional employer fees per employee to cover taxes, insurance, workers' comp. The extensive process and costly investment in recruiting and retaining well-trained compliant staff need to be protected. Putting such a bill in place will make the home and community-based service needs more critical and perhaps more unbalanced. It is, as it is, agencies are turning away cases daily as they don't have enough staff to keep up with the referrals. Rather than impose prohibitions on agency hiring contracts and fees to clients, it may be better to find ways to feed the workforce needs by building the pipeline. A stronger pool of qualified workers paid a reasonable wage will help fill the voids and give choice to client and family in their decision to hire an agency or to do direct hire. From prior testimony today and follow-up Q&A, it was stated that this is just for Medicaid, specific to the self-directed PCA services. I ask that you review the bill language and consider clarifying the private pay allowances versus the Medicaid state-funded self-directed care allowances. Clients do have the option to hire privately and pay privately. This would not just apply to Medicaid-funded services as I read it. Yes, people should always have choice, but taking away qualified trained staff from an agency does not support successful agency-based services. It tends to create voids and gaps. Why consider imposing further constraints on agencies who are already struggling with workforce? May I suggest instead that the focus be on supporting current and future workforce demands? Thank you for the opportunity to submit testimony.
Thank you, Tracy. Any questions? Comments? Seeing none. Thank you for your testimony.
Thank you.
Next is Parisa Chamarki Goodwin. And correct me if I'm wrong on that pronunciation.
Thank you, Senator Moore. My name is Parisa Chamarki Goodwin, and I am the Executive Director of the Connecticut Oral Health Initiative. We are testifying in support of Senate Bill 191. The Connecticut Oral Health Initiative is a statewide nonprofit that advocates for access to quality oral health services for all Connecticut residents. We engage with people on Medicaid, low-income families, and marginalized communities to understand their challenges accessing care and advocate to alleviate those barriers through policy changes. So we represent people on Medicaid and people having difficulties. We work with providers, but we do not represent their interests. We support this proposal to clarify payment practices and streamline the provision of non-emergency dental care for community health center patients. We hope this legislation will secure and encourage bundling of dental services that can appropriately be delivered in one visit, preventing patients from making multiple visits when unnecessary. The issue is of importance to us because the populations we advocate for often struggle with transportation, arranging childcare, and missing work. The origin of this bill, as the DSS commissioner stated, is related to the concern that some health centers may unbundle services in order to maximize visits and thereby maximize revenue. As such, centers are reimbursed on a per encounter or per visit basis. It's important to note that community health centers are a very critical part of the safety net, that providing dental care is expensive and often at a financial loss for such centers. At COHI, we do not believe that CHCs provide care for profit. We believe that they provide dental care because they know how important it is for their patients' overall health and well-being. However, we do believe that encounter payment is problematic as it incentivizes turning of patients or scheduling as many visits as possible. A per encounter payment structure will result in short, frequent appointments, making care delivery less efficient and more expensive. Unbundling of dental services is one symptom of a larger problem with the current payment model. We hope that the legislature will continue to have discussions about payment that covers cost and incentivizes quality and appropriate care in a patient-centered manner. We respect the time constraints of a short session, and we're not requesting changes to this bill language from our perspective, but we do hope that our comments on the larger payment problem will spark discussion and that this issue can be addressed in the coming years. Thank you so much for the opportunity to testify. I can be reached with any questions by email or phone. My contact information is in my written testimony. Thank you so much.
Thank you for that testimony. Are there any questions, comments? Seeing none. Thank you. Have a good day.
Thank you.
Next is Jordan Fairchild.
Thank you, Senator Moore. Good afternoon, Senator Moore, Representative Abercrombie, and distinguished members of the Human Services Committee. My name is Jordan Fairchild, and I am the coordinator and community organizer for Keep the Promise Coalition. We are a grassroots group of advocates with lived experience of mental health, addiction, and co-occurring conditions and disabilities. I'm here to testify in support of SB 283, an act eliminating income and asset limits for the MedConnect program for persons with disabilities. Many of our members want to work. For those who can, MedConnect provides assurance that many of their medical expenses will be covered. But for however good MedConnect is, the current income and asset limits for the program often act like a ball and chain for many in need of the coverage it provides. These limits force people to sacrifice their career and financial growth, all for the sake of maintaining their coverage. They make it impossible for people to save up in case of emergencies or unemployment, which can also come as the result of their disability. I'll return to that in a moment, but I'm confident that removing these limits will eliminate an unnecessary barrier to successful living for many people with disabilities. As myself and others have mentioned, there will come a day for all of us when we are no longer able to work. And for those people with disabilities who MedConnect is intended to serve, this day can come early or can come unexpectedly. This event will make these individuals ineligible for MedConnect. When that time comes, they will have to fall back on Husky C in order to keep their coverage. Husky C provides coverage for many people who are elderly or disabled and not able to work, but it has the lowest income limits of any Husky program, just $941 in most parts of the state and $1,052 in Fairfield County. That's 84 and 93% of the federal poverty level, respectively. These income limits are below the federal poverty level. Husky C also has an extremely low asset limit, just $1,600 for a single person and $2,400 for a couple. Even though many Husky C clients qualify for Medicare, Husky C provides critical coverage which Medicare simply does not, including dental, hearing, vision, at-home care, and significantly better behavioral health coverage. To begin to do right by people with disabilities who need Husky C's coverage, we can raise the income limit to at least match that of Husky D for an effective income limit of at least 138% of the federal poverty level. And we can also increase the asset limit to $5,000 and $7,500. MedConnect does a lot of good for a lot of people who work, and this bill would make it even stronger. But please also consider strengthening Husky C for when people cannot work. Thank you so much for the opportunity to testify today.
Thank you, sir. Representative Hughes.
Thank you, Madam Chair, and thank you so much for your testimony. That lived testimony is so important that it's not a static state that you're talking about people needing MedConnect for, that it can change, your health needs change, as well as the ability to work changes. And that's why we need a broader, that we need to raise the limits or eliminate the limits. In your experience with folks that you're in conversation would this cost the state, in your view, to raise the asset and income limits for MedConnect?
So, there would be a fiscal note, and, I understand that based off of the way that those limits are calculated, we would get reimbursed 50%, I believe, if I remember correctly, by the federal government. I think that it would also create a lot of growth and savings in other areas, like people having access to things like dental might be able to avoid really significant problems later on that stem from not paying attention to just the general upkeep and health of people's dental health. Same can be said about vision and hearing and other sort of areas that are covered by Husky C, but maybe not Medicaid or Medicare rather, or certainly wouldn't be covered if they don't have that coverage.
Thank you. And finally, just would you see, in terms of your sustainability to work, your life cycle, that would be more durable if we raise the limits in terms of economic self-sufficiency?
Absolutely. Both for Husky C and MedConnect, those limits are really preventing people from going and getting their careers and developing and growing. And ultimately, a big part of it is even just saving for like emergencies. Once people are unable to work, as many people in the disability community know, that's a big concern. It could happen unexpectedly, as I mentioned, and it could really mess with people's plans and financial planning. So having the ability to save and have some more assets and bring in some more income to be able to support that would be, I think, very beneficial. Yeah. Thank you for your question.
Are you good, Representative Hughes? Thank you. Anyone else? Thank you, Jordan. Good to see you. Thomas Burr.
Yes, good afternoon, Senator Moore, Representative Abercrombie, and members of the Human Services Committee. My name is Thomas Burr, and I am the Community Affiliate Relations Manager of the Connecticut chapter of the National Alliance on Mental Illness, otherwise known as NAMI Connecticut. I am testifying today in support of SB 283, an act eliminating income and asset limits for the MedConnect program for persons with disabilities. You should know that NAMI is dedicated to building better lives for those with lived experience with mental health conditions and their families. NAMI Connecticut and its 9 local affiliates provide support groups and educational programs for people with mental health conditions and their loved ones, and advocates for policies to improve the lives of people affected by mental health conditions. On a personal note, I have an adult daughter who is disabled and greatly appreciates the healthcare coverage she receives through the state of Connecticut via Husky C. You have my written testimony, and frankly, in the interest of time, I'd simply just like to echo what Holly Hackett, Sheldon Tubman, Allison Weir, and Jordan Fairchild have just recently testified on this bill. They did a wonderful job explaining the differences between MedConnect and Husky C, as well as the benefits of what we would like to see change. So in conclusion, on behalf of our organization, our membership, please amend SB 283 to include the raising of the Husky C income limit and asset limits. Thank you for your time and attention.
Thank you, Mr. Burr. I personally want to thank you for the work you're doing. We need you now more than ever. So
I appreciate
I
that.
appreciate you much.
Thank you very
Any
much.
other comments? Seeing none. Thank you, sir. Ken Laline.
It's Ken Laline, but I'll get going here. Thank you very much, Senator. That's okay. Distinguished leadership of the Human Services Committee. My name is Ken Laline. I'm the CEO for the Community Health Center Association of Connecticut, and is speaking on Bill SB 191 today. We believe that the modernization of an updated program for statutes to reflect what is our current practice is very beneficial. We show that the health centers and especially the Health Center Association has been helpful to the health centers around the state in expanding access in so many new sites. We've got a site in every legislative district. We have had expanded services that now include, medical, dental, behavioral, and very often now pharmaceutical, and that is continuing to grow as we see the issues in the marketplace. The number of health centers around the state continues to grow. 100 sites as we see it now, and over 4,000 employees. We also have expanded programs. We've been supporting of chronic disease management programs and helping patients get low-cost medications through the 340B program, and enrolling thousands in health insurance, both Medicaid and commercial, in a partnership with Access Health. The patients that are seeing in the health center predominantly are in the Black and Brown communities. We see that there is a special need that is needed to take care of these patients, and we want to provide those services, and the health centers are doing a fabulous job. There's over 380,000 patients that come to the health center on an annual basis. That's 1 in every 9 citizens of the state of Connecticut. What is missing a little bit here is on the encounter rate, which is discussed in SB 191, but the encounter rate is not recognized for all those incremental changes that we just talked about. the different services that we're providing, the expansion of services, expansion of access, expansion of programs, all have an incremental cost to, incremental cost to those, but the incremental revenue has not been keeping up with that. The mechanism that's in place to provide for those changes in reimbursement is not being utilized in an appropriate manner such that it can actually benefit the patients in the state of Connecticut. While costs have continued to escalate over the years, no change in the payment structure there is a structure to put that in place, but it has not been taken advantage of. The transparent process is needed to be identified and recognized, and the calculations can be made. We will be glad to sit with DSS and the advocates there to make sure that patients are given the appropriate services at the appropriate times and reimbursed properly. Thank you very much for your time. I have submitted written testimonials.
Thank you, Mr. Lemaine. Are there any questions, comments? Seeing none, thank you for your time and testimony.
Thank you.
Mag Morelli.
Hi, good afternoon, Senator Moore, Representative Abercrombie, members of the committee. My name is Mag Morelli, and I'm the president of Leading Age Connecticut, a membership association of 130 not-for-profit mission-driven organizations representing the entire field of aging services and senior housing. On behalf of Leading Age Connecticut, I'm pleased to testify on several bills today. I'm just going to touch on actually 3 of them that we've submitted testimony on. The first is Senate Bill 286, which is the Act concerning deadlines for mandatory reporting. We have no objection to the modification of the penalties to report, but we do raise a concern about the proposed 12-hour time period, as the requirement is to report a reasonable cause for suspicion, which is a little bit higher level of suspicion. But we would be happy to talk to the committee about this. We've had discussions about this before. There are various reporting requirements to various departments that aging service providers have. And so happy to sit down and talk, and also very happy to work with the department and others to help facilitate the reporting process for the wide range of mandatory reporters. It's not just aging service providers on that list. And so we'd be happy to assist in that. On Senate Bill 290, an act concerning certificate of need for long-term care facilities, we are pleased to be working with the Department of Social Services on modifications to the current CON process for nursing homes. Our goal is to make the process more efficient and collaborative as we seek to rebalance the long-term care system in the state. You know, we're not in full agreement with the language proposed in the bill before you today, so we've attached alternative proposed language that we've also offered to the department for consideration. Our goal is to create a more collaborative process, and that's highlighted in our proposed language by the addition of the opportunity for informal conferences between the provider and the agency during the CON process. We also recognize the potential need and/or desire to replace older nursing home facilities and have included clarifying language on that process. And we hope that our language captures the agency's desired attributes for those replacement facilities. Finally, our proposed language adds the state's long-term care services and supports rebalancing plan as a criteria that the agency can consider when they're reviewing a CON application that's currently not part of the process. So we thank you for considering our proposed language and look forward to working toward establishing a collaborative and efficient process to help the nursing home sector plan for the future of aging services. And finally, on House Bill 5333, an act concerning the PACE program, Leading Age Connecticut strongly supports this bill, which would enable and hopefully encourage the Department of Social Services to submit a state plan amendment to add the program of all-inclusive care for the elderly, or the PACE program, as an option in the state's Medicaid program. Leading Age Connecticut board member Andrew Banoff spoke earlier on this bill, so I won't repeat that testimony, but just know that we would be very, very supportive of this program and willing to work with the department and the committee to make sure that the process went forward in a safe and affordable manner. So thank you for hearing our testimony. I'd be happy to answer any questions.
Thank you, Mag. Any questions, comments? Representative Hughes?
Oh, thank you, Madam Chair, and thank you, Mag. I'm sorry I missed the couple of verbs on the reporting mechanism that you said. Were you suggesting different language for that bill about suspected reasonable cause for abuse and neglect?
No.
I missed that part.
Oh, I was saying because you need to have reasonable cause to report, and it's not just a suspicion, it's a reasonable cause for suspicion. We're just wondering if 12 hours was too short a period of time. I know there are certain reports that say a nursing home needs to make immediately to the department and immediately here, but before you report to the to DSS, you do some investigation to make sure that there's a reasonable cause to make that report. So just questioning the 12-hour time period from 3 days to 12 hours, and willing to talk to the committee about that.
That's what I thought. If you just had to come up with a compromise, what would it be? 24 hours? I'm just curious.
Well, you know, there's a 24-hour requirement right now to the Department of Public Health, but that's only for healthcare, like nursing home providers.
Right.
Actually, the current language, the 3 hours, I mean, the 3 days, right? Was it 72 hours?
72
was a
hours.
compromise years ago when it used to be 5. It used to be 5 days. So I think that we could absolutely talk about what might be, maybe if 3 days is too many, is too long, if we can look for a different time period. But I think 12 hours is a little bit short.
Thank you. And did you submit testimony about that? I'm sorry.
Yes, we
I
did.
missed that
Yes,
part.
we did.
Great. That's all I want to know. Thank you. Thank you, Madam Chair.
Thank you. Any other comments? Meg, I'm writing that down to look at that. All
Oh,
right.
great. Thank you.
That's time. Thank you. All right. Seeing no other questions, I'm going to move on to Suzanne Lagarde.
Thank you.
Yes, good afternoon, Senator Moore, Representative Abercrombie, and members of the committee. My name is Dr. Sue Lagarde. I'm the CEO of a health center in New Haven, and I would like to briefly address Senate Bill 191, an act concerning FQHC payments. This morning, we all heard Commissioner Gifford say that FQHCs are not reimbursed on a cost basis. Strictly speaking, this is correct. However, she also stated that FQHCs are reimbursed on an alternative payment methodology. This is incorrect. FQHCs are reimbursed under the prospective payment system methodology. Alternative payment methodologies is a term of art recognized under federal law, and the FQHC has to opt in. This is not the case in Connecticut. The commissioner's statements regarding costs notwithstanding, CMS is very clear that costs do need to be taken into account in determining health center rates. Federal law clearly requires states to adjust FQHC rates based on changes in scope. CMS is also clear that as long as the health center demonstrates a change in scope evidenced by an increase in the volume, quality, or intensity of a particular service, the state must increase the rate accordingly based on incremental costs. So while not strictly cost-based, CMS is clear that costs do have to be taken into consideration. Back in 2001, per federal mandate, all health centers in this country, their Medicaid reimbursement rate was set based on costs and visits over the preceding 2-year period. Since 2001, the only increase in rates in Connecticut have been an annual minimal increase, the MEI or Medicare Economic Index. This averages around 1.5% annually. So for 20 years, despite several requests for rate increases, my health center received no increase beyond this minimal annual inflationary figure, the MEI. Last September, after many requests, we did receive a disappointingly low 1.6% increase. Like many health centers, over this time, we introduced numerous changes in scope, such as dermatology, optometry, podiatry, and the list goes on. Yet, despite indisputable evidence of these changes in scope, we were repeatedly denied any increase in rate. Committee members, the current system is broken. If you were to consult with any national industry experts, as I have, they would tell you that CMS statutes are not being followed in Connecticut. All we ask for is a fair reimbursement rate commensurate with services delivered. Without this, we struggle to stay afloat. The opportunity to innovate is stifled. Our desire to pay our staff fair wages is impossible to fulfill. The health centers are the safety net for nearly 400,000 Connecticut residents. Other states have rates which in some instances are double and even triple those here in Connecticut. Please help us to remedy this situation. Thank you very much for your time.
Thank you. Any comments, questions? Seeing none, thank you. Mark Maselli.
Hold on one second there. Well, good afternoon, Senator Moore and Representative Abercrombie and distinguished members of the Human Service Committee. Thanks for the opportunity to speak on Senate Bill 191. And I'm Mark Maselli, President, CEO of Community Health Center. And I would like to suggest the committee amend the bill with substitute language addressing cost-based reimbursement as allowed for it in federal statutes. And the substitute language is included as part of my written testimony. I think you've heard from Ken and Sue about the role health centers play in the state. And I know many of you are very familiar with them. Our health center last year cared for about 100,000 patients in about 200 locations. 150 of those are school-based health centers. And so from Stanford to Groton and Clinton to Enfield and all sites between. But we also played an important role, as all health centers did, but we were asked by the governor to set up the 4 mass vaccination sites. So in Pratt & Whitney Airport at East Hartford, Middletown, Danbury, and Stanford, we set up those, as well as setting up COVID sites in many of your communities across for testing. But, I think we all sort of know this, that the healthcare needs in Connecticut are chronically underfunded. And currently, as Sue indicated, Medicaid allows states to reimburse health centers at 100% of their costs. And I know that, everybody says, well, somebody else is getting paid less. The reason health centers got this is because there was an enormous crisis that was happening back in the 70s and 80s. We're in our 50th year here. There were not people taking care of the people who lived in cities and rural places, people lived in poverty, diverse populations. And health centers were there. They were paying for the, caring for the uninsured and undocumented. And the federal government said, we're giving you grants for that, but it's being eaten away by the lack of Medicaid reimbursement. So our money is not being used as it needs to be. And so this policy got set up, and Connecticut was really in the vanguard, and that changed. And we're asking to get back to the vanguard position that Connecticut had. This is really important. And as Sue noted, the department currently has regulations which we meet to say, look, we'll give you a rate adjustment if you do big things. We opened a huge facility in Hartford, largest pediatric center in the state of Connecticut, opened a new facility in Stanford, put in the applications and just summarily denied. The department shouldn't be setting policy here. The General Assembly should, about how it's going to provide for reimbursement. So I encourage you to take a look at the testimony and the proposal. And thank you for the work that you all do on behalf of the citizens of Connecticut.
Thank you. And thank you for the work that you do. We appreciate it. We know we would not be able to survive without your support and the work that you do. I'm looking to see if there are any hands up. Seeing none. Thank you, Mr. Maselli.
All right, thank you, Senator.
The next is Arvind Shaw.
Yes. Good afternoon, Senator Moore, Representative Abercrombie, and distinguished leadership of the Human Services Committee. My name is Arvind Shaw. I'm the CEO for Generations Family Health Center in Eastern Connecticut. I'm submitting testimony on SB 191. In 2021, last year, Generations served 18,500 unduplicated patients. And we specialize in providing care in this rural part of the state for traditionally underserved communities. We do not turn away patients. We've been, as you've heard from my other colleagues, we've been very busy in the pandemic providing services to folks remotely and through telehealth. We really appreciate your assistance in being able to do that. However, I do have to say that the Department of Social Services approach to rate setting is not in the best interests of patients that it's trying to serve. To serve these patients, the dental benefit provided by the Medicaid patient, which is more than 1 million patients, needs to meet the community standard of dental insurance that is provided by other reputable carriers in the Connecticut workplace. Our Family Health Center has been operating for 39 years under a rate setting system that does not reflect the cost for care. We've expanded the number of sites. In fact, we've more than doubled our services. We invested $20 million in our capital infrastructure. We added a new site which improved 40% of all of our services. And we got a rate adjustment from DSS of a few pennies visited. I rounded it up to 0. Needless to say, the increase did not cover any of the additional expenses, and many of these patients are still waiting untreated. Network inadequacy. Long ago, there was a 13-year-old who presented in the ED with an abscess in a tooth, and because of the seriousness of the proximity to the brain, this child was admitted for 10 days to Daycombe Hospital. A week later, she was released. A week after she was released, we picked her up on the Across the Smiles dental program, our mobile program. And so we have patients like this who are on waiting lists, waiting to gain access to a system of dental care which is rife with denials, prior authorizations, financial barriers, you name it. It doesn't serve the very fundamental thing that patients are asking: when is my appointment? The lack of dental treatment options increases the use of opiates. It is also routinely documented. When patients go to the ED, they're provided with opiates and painkillers while they wait treatment. This increases the risk for opiate addiction. And unfortunately, because of the scarcity of dental treatment options, the patients are exposed to these additional risks and infections. Medicaid dental benefits are subpar. The Medicaid program covers more than 1 million lives in Connecticut.
Mr. Shaw?
Yes, sir.
You're actually coming up on your 3-minute
oh my God.
mark. Yeah, would you like to summarize?
Well, I'll summarize. You can read my thing, but I just basically want to say that you really need to answer these questions if you really want to have an honest discussion. How many patients are going to the ED? How many days are lost in school because of lack of inadequate dental care? What is the state's plan to increase access? What are the downstream costs of opiates? How are other states restoring equity for dental patients? Why does DSS not adjust risks for rural transportation and high-risk patients like other states do? Why is the state justified in providing subpar benefits for Medicaid patients? Before you vote, please may I ask that you answer these questions. Thank you so much.
Thank you, Mr. Shaw. Any comments, questions? Seeing none. Thank you, sir. Next is Matt Barrett. I don't see him. I'll go on to Christy Covell, and if Mr. Barrett comes on, I'll go back. Christy.
Hi, good afternoon, Senator Moore, Representative Abercrombie, and distinguished members of the Human Services Committee. My name is Christy Koval. It's nice to see you this afternoon. I'm the Director of Public Policy for the Alzheimer's Association Connecticut chapter. The Alzheimer's Association leads the way to end Alzheimer's and all other dementia by accelerating global research, driving risk reduction and early detection, and maximizing care and support. I'm here today to provide comment on House Bill number 5332. Currently, right now, there are 80,000 people who are living with Alzheimer's or other dementia in Connecticut. We estimate that this number is going to rise to 91,000 just in a couple of short years. Connecticut is the 6th oldest state. We're one of the oldest in the nation, and age remains the biggest risk factor for developing Alzheimer's disease. So we are going to see our numbers continue to go up. More than 80% of help provided to folks in the United States is from family members or friends or that informal support system. And interestingly enough, about 66% of people who have Alzheimer's or dementia are cared for in the home. And many of our family caregivers really do rely on home health agencies to bring in a supportive person to provide that type of care. I cited in my testimony that the Alzheimer's Association Dementia Care Best Practice Recommendations really looks at person-centered, focused when providing that care. And as we know, that the key to enriching someone's life, particularly as they go through the disease process, is to surround them with someone who really knows them quite well. So we know that, our families want to have the flexibility to hire employees privately. We want to see this opportunity afforded to them, even if this person is working for a home care agency, to be able to have that flexibility. So we are testifying in support of this legislation because we know this bill will strengthen consumer rights, empower our families' choice in selecting a caregiver who can work with their loved one, and will enrich Connecticut's home and community-based services, which we know is where people prefer to age in place. I am happy to answer any questions or provide any additional comment. Thank you.
Thank you for your testimony. I do see Rep. Dathan.
Thank you very much, Madam Chair, and thank you, Christy, for your testimony today. It's really big. I mean, my mother, as you know, had Alzheimer's and spoken a lot about that. And when I saw this bill, the first thing I thought of is the limitation on families that have parents or loved ones that suffer from Alzheimer's. I know with my mother, she just, even if she didn't know the person's name, it was the recognition and that continued visitation and work that was done on behalf of those people. And that was probably one of the biggest concerns. And I was thinking a lot about how the needs of these patients go up over time. And I think the flexibility for families to be able to engage with a caregiver on a more increased need basis is so important. And that is probably one of the reasons that I think that this bill is so important. And I'm so glad you came to testify. Can you share with the community committee and maybe some statistics about, if there's any sort of indication and how patients do when they have a caregiver that they know? Is there any sort of data that comes out about consistency in care?
There is. In that report that I cited in my testimony and the best dementia care practice recommendations, we do know that a consistent caregiver, and as we know in nursing homes, a consistent staffing patterns, it often leads to better outcomes. You want to have someone who is able to feel supported in this disease process. It's the empathy. Our family caregivers oftentimes will rely on that professional support person, and they consider them oftentimes a member of their extended family. So there's less agitation, maybe easier to provide ADLs to that person, activities of daily living, even when the person, is significantly more challenged, because the person's able to have that empathetic communication, even if the person is becoming more nonverbal.
All right, my dogs are in full agreement with you. I really appreciate it. And thank you so much for all your advocacy. It's so important. Thank you, Madam Chair.
Thank you, Representative Dathan.
Representative Hughes.
And thank you, Madam Chair, and thank you, Christy. I remember when we worked on the Alzheimer's Task Force in 2014, when we were the 7th oldest state, and now we're the 6th oldest state. And so I guess my question is, in your testimony, have you provided your suggestions for really updating in real time the responsive needs to respond to this increase of care and consumer-based, person-centered focus? I know you addressed a couple of bills, but in your written testimony, and I'm sorry I haven't looked at it, have you provided that testimony for those other bills in terms of updating our responsiveness to the Alzheimer's, I guess the ecosystem that we are facing now as the 6th oldest state?
Yes. So to answer that, it's not in the testimony, but I think for the committee's knowledge. So Connecticut just received, the Department of Public Health received a significant grant through the CDC to do a very comprehensive update for the Alzheimer's state plan. And this is looking at it with the public health lens. We were one of 7 states funded for this. So it's going to look at things like early detection and diagnosis, avoiding preventable hospitalizations, and supporting caregivers. This is a really large undertaking. The first stakeholder working group was last month, and we are forming subcommittees now. This work is going to take about a year. Amy Marizzi, who's the chronic disease director, and her team are taking this up. We are, of course, providing some supportive role to them as well. But we're really looking forward to this because I think there are a number of bills in many committees that really are looking at different aspects of care and how we meet the growing needs. But comprehensively, I think we still need to do quite a bit of work in terms of how we're looking at Alzheimer's disease and other dementias and how we're supporting people through that span.
Great, thank you so much. I think this committee especially will look forward to hearing the work of that CDC workforce grant.
Thank you. Seeing no other questions. Thank you, Christy.
Thank you very much.
I see Mr. Matt Barrett.
Good afternoon. Good afternoon, Senator Moore. Thank you so much for courteously allowing me to testify out of order. If I needed to, I think I could get a note of permission from Representative Hughes, as she and I left the Aging Committee, I think, at the same time. But I am so grateful for the opportunity to testify. And good afternoon also to Representative Abercrombie and to the distinguished members of the Human Services Committee. My name is Matt Barrett, and I'm President and CEO of the Connecticut Association of Healthcare Facilities. And I appreciate the opportunity to testify on 2 bills on the agenda this afternoon. The first being Senate Bill 290, an act concerning certificate of need for long-term care facilities. And I do want to applaud the committee for raising this bill, and also applauding the Department of Social Services for advancing reforms in nursing homes and the nursing home certificate of need process. I think this is the appropriate time to do so. Revisions to the process that expedite applications and encourage construction, renovation, and replacement of Connecticut's aging nursing home infrastructure make tremendous sense at this time as our state prepares to address the forecasted needs of our dramatically aging population. And we're especially pleased to be collaborating with the Department of Social Services on this process and to have the opportunity to make detailed recommendations to the Human Services Committee later this session for your consideration. And we are most especially interested in addressing the goals of reducing excess licensed bed capacity consistent with the state's long-term care right-sizing and rebalancing goals, as we at once modernize and advance high-quality nursing homes in our state, but done so in a way that doesn't lead to the unnecessary closing of nursing homes that will be needed to address our future long-term services need and support needs. So we do support this and look forward to the opportunity to continue to work with DSS and make recommendations for the committees on consideration. The next bill is Senate Bill 281, an act concerning penalties for the unauthorized use of rate increases earmarked for staff wage enhancements at nursing homes. And this bill would authorize, in the case of a nursing facility that received a rate increase for wage enhancements for facility employees, it would authorize DSS to assess a civil penalty if the facility fails to use the rate increase for that purpose. And we completely support the department's efforts to assure compliance with these very important provisions. The bill provides for a civil penalty of up to 50% of the rate increase earmarked for staff wage enhancements. It's a significant penalty, and therefore we support we also recommend that the provider hearing rights be guaranteed, not authorized as in the current draft, and that any penalties be stayed if a provider is exhausting appeal rights, including appeals to the Superior Court, until the culmination of those efforts. But again, thank you so much for allowing me the opportunity to testify out of turn, and I'd be happy to answer any questions that you might have.
Thank you, Matt. We know that you attend a lot of meetings, so we appreciate you being here. Are there any questions? There are not, so thank you.
Thank you so much.
The next is Mary Liz Williams.
Yes, I'm here.
Hi, how are you?
Hi, I'm good. How are you?
Good, I can hear you.
You can hear me, you can't see me.
I can hear you, but I can't see you.
Oh, I don't know why that is, but
That's okay.
Okay, well, good afternoon. Senator Moore, Representative Abercrombie, and distinguished members of the Human Services Committee. I am speaking in support of House Bill 5332. And I'd like to say that in August of 2018, after my mother's death, my family exercised a long-term care policy to begin live-in home care for my father with dementia. Oh, there we go. Hold on, I'm just sending my video. In order to access the $265,000 of long-term care insurance, we were required by the insurance company to hire our caregiver through an agency. The agency provided our caregiver and manages payroll. And for these services, the agency has been well paid. Over the course of 4 years, our caregiver, who earns $13 hourly, she has been paid $13 hourly, and as our insurance runs out, the agency has been paid approximately $500,000 for the last 4 years. Somewhere amid the details of that contract is a clause that states we would be charged in excess of $10,000 should our caregiver choose to leave the agency and work directly for my dad. Because of a law that was passed a few years ago, our caregiver is not financially penalized if she makes this decision, but my father is. It is currently legal to prevent our caregiver from choosing to work with my dad unless our family pays this very heavy fine. So she is free to make the choice, but the handcuffs remain, with more money required from my dad, even after hundreds of $1,000s have already been paid to this agency. My father's long-term care insurance fund is nearly drained. Soon he will face losing his only caregiver of 4 years, or he will be made to pay many thousands of dollars to keep his care status quo, regardless of what he, his caregiver, or our family would freely choose. The penalty levied upon those who use the services is just a cash grab to those who have already paid handsomely over time. My father, whose dementia has worsened over time, has come to depend upon his caregiver, feeling safe, secure, and at peace with her managing his care. To him, she is a friend, a trusted companion, sharing his home and his life. He is very attached to her. We as a family rely on her as well. These relationships are more than transactional. They are emotional relationships built on trust, mutual respect, and friendship. Please consider the extremely high cost of this kind of care and how much is paid over time. Considers that the workers are free to come and go at will. And please consider that the families are penalized because they have grown dependent on a person and because the agencies could not indenture the caregiver. Thank you for your time, and please vote in favor of this bill. Thank you.
Thank you. I don't see any questions for you. So thank you so much, Miriam.
Thank you for your time. Thanks.
Olivia Rincas. I don't see Olivia. If she comes on before we're through, I'll go back. Mark Anthony Galucci.
Hello, can you hear me?
I can, and I can see you.
Okay. Thank you very much, Senator Moore and other distinguished members of the committee. I'm here to testify. I'm Mark Anthony Galucci. I'm the Chief Advocate at the Center for Disability Rights, and I'm here to testify the position of the center on Bill number 283, an act eliminating income and asset limits for MedConnect. So you've heard from so many people already why this is so important. CDR has a staff person who testified earlier, Rick Famighetti, he was actually the inspiration for this program. I want to make a historical note that the Department of Social Services was opposed to this bill when it came out originally. It's because of the strong support of Governor Rowland that it went through. So this program is critically important to give people the dignity of work and make them tax-paying citizens. The Center for Disability Rights feels very strongly that people with disabilities should be offered an avenue for breaking their dependency on government programs by gradually weaning themselves off and being able to go to work and not fear jeopardizing their critical community-based services. So we think that this program should be expanded. I was disappointed to hear the testimony from a commissioner in opposition to this bill. And I want to point out that she mentioned individuals who don't make enough to pay the premium. I know several of those individuals who are working part-time because they need to avoid a spend down and they need to have extra money to pay their bills. And if they didn't have this program and they couldn't go to work part-time, and I'm very serious about this, I'm not making this up, they would either be in a nursing home or they'd be homeless out in the street or dead. I know some individuals I am convinced will be dead without this program. And I know some actuaries figuring this out for Medicaid, they may say that dead means 100% savings for Medicaid, you know, but for us, we think dead is 100% failure on the part of all policymakers to be able to enable people to have the dignity of work and be able to be safe. I also urge you, even though this is a little related, like other people, to consider increasing the income and asset limits for Husky C. These were set in 1970. They need to be increased. Connecticut had the distinction of having the lowest income and asset limits of every state in the country for a number of years, and only recently one state was caught up to us. We have much lower income and asset limits than Mississippi, Louisiana, Arkansas, and all these states that have much, much lower costs of living. Every day I work with consumers who want to leave nursing homes, and many of them are stuck there. They're dependent on money files a person to move them out to find them housing because they've been forced to impoverish themselves in order to afford to get Medicaid for institutional care. Now, don't get me wrong, I'm a big fan of MFP. I'm one of the original group of people that started the nursing facility transition program. I think it's wonderful. However, we need to allow for people to be able to accumulate some wealth so that they can move themselves out of nursing home when they feel like it, instead of having to wait in a nursing home. And I have more details in my testimony here that you can read, and I thank you for this opportunity.
Thank you, Mr. Anthony. One thing I want to point out, I'm hoping and praying and believing that we don't look at 100% of Medicaid savings when someone's died as a saving, but a loss of a life. So thank you for your testimony. I don't see any other questions. Thank you. So the next is Kathy Flaherty.
Good afternoon, Senator Moore, Representative Abercrombie, members of the Human Services Committee. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project. We are a legal aid agency representing people who are eligible for mental health services from the Department of Mental Health and Addiction Services. I'm here to join my colleagues in expressing support for SB 283. I have been a legal aid lawyer since the late 90s, and MedConnect has absolutely been a life-saving program for people because if they can get a little bit of earned income, they then are eligible for Medicaid and can get access to those long-term services and supports, the home and community-based services they need, and medical care. We wouldn't be the first state to eliminate income and asset limits. I know we hate being on the cutting edge of things. We like keeping things the same as they always are, but there are other states that have already eliminated income limits and asset limits for their Medicaid for people with disabilities who work, and we should join them. But we also need to help the people with disabilities who are unable to work, whose only eligibility is Husky C. And I will tell you why we have to do this. I have spent years telling people, meet your spend down by going to the emergency room, because the emergency room has to provide you medical services, even if you can't pay. If you are trying to meet your spend down by getting really expensive prescriptions, if you cannot pay the bill, the pharmacist does not have to give you your medications.
but an emergency room does have to stabilize you. And that is the worst incentive for medical care and no way to run a healthcare system. So I would really urge you, and I heard you ask some of my colleagues earlier, well, what if we can only do one of these things? I would urge you to think more creatively. Why do we only have to do one of these things? Why can we not have the political will in this state to use some of the federal dollars that have come in? Or why can't we ask the rich people in this state to pay a little bit more if we really truly do believe that healthcare is a human right? I didn't submit written testimony on 288, but I would just point out, I totally am fine with excusing the Department of Social Services from notice requirements during an emergency. I think the way the bill is written, it would also automatically kind of preemptively give them the ability to avoid notice and public comment requirements, which is great when we have an administration that we believe they're doing things that we support. Might be more concerning if they're doing things we don't. If there truly is another emergency in the future, they'll probably be granted that waiver again. So we should deal with it at that future emergency, not prospectively for all time.
Thank
And that's
you,
all I
Kathy.
have.
Any questions? Seeing none, thank you for your time and your testimony.
Thank you.
Maribel Martinez.
Good afternoon, distinguished members of the Human Services Committee. My name is Maribel Martinez. I'm a patient and the board chair of Fairhaven Community Health Center. Thank you for the opportunity to testify regarding Senate Bill 191. As you consider potential changes to rates for FQHCs, know that the current system is already inadequate. I became involved with the Fairhaven Board of Directors because of the positive impact that community health centers have had on my family and the need for health centers like ours. I was raised out of state in a community much like the one served by Fairhaven. As my parents aged, there were significant health issues. We faced difficulties in managing the healthcare system. At age 70, my mother was diagnosed with stage 3 colon cancer. She did not have health insurance, not because she didn't qualify, but due to missing the enrollment period. When none of the specialists I called would see her because she was uninsured, our community health clinic assisted us with referrals to specialists and a Spanish-speaking cancer support group. The group helped her understand her illness and build support with others in her own language. And thankfully, she recovered from her cancer. Years later, my parents were both diagnosed with crippling dementia that left them homebound. Through an elder care program at their community health center, a primary care physician made home visits. A case manager helped us obtain home health aid services. We could not have predicted the enormous support that this provided us at such a difficult time. It was not easy, but this supported us to keep our parents home and together until they died. As you heard from Dr. Lagarde earlier, Fairhaven added new health services. The final decision approved an increase that was just a sliver of what was requested and needed. Without fair reimbursement rates, our ability to fully meet the needs of our patients and community is limited. It is simply not about a health visit. It's taking action to eliminate the impact of health disparities. It's working beyond the clinic walls and creating opportunities to bring healthcare into the neighborhoods. It's going into the homes of people too fragile to leave, reaching people too afraid of big health systems, helping to address the environmental and socioeconomic issues, and building community that promotes good health for everyone. As board chair, it is my responsibility to advocate for our patients. Honestly, it is all of our responsibilities. Adequate rates will allow FQHCs to address social determinants of health and create unique programs that meet the immediate and impending health needs within the community, much like what my parents needed. Thank you on behalf of Fairhaven Community Health Center and its patients for letting me talk today.
Thank you for your testimony. I don't see any questions, so thank you. Have a good day. Diane Smith.
Yes, good afternoon. Good afternoon, Chairs Abercrombie and Moore, and distinguished members of the Human Services Committee. My name is Diane Smith. I am 52 years old, and I am the first person in several generations of my family to have not committed suicide. With 3 hospitalizations and decades of treatment over the last 40 years, I battle with my chronic depression every day. Although I do not receive Social Security, the Department of Social Services and the Bureau of Rehabilitation Services of Aging and Disability Services have found that the severity of my disability qualifies me for services and the MedConnect program. I am a single person and I live with my mother. Having access to the MedConnect program since 2019 has had an immensely positive impact on my life. MedConnect allows me to work full-time as a special education teacher at a private special education approved program for students with emotional and cognitive disabilities. My employers are flexible and understanding. Working as a special education teacher for students with emotional and cognitive disabilities allows me to give back and prepare them for their lives after they graduate, and hopefully make their lives a little easier. However, the asset allowance for the MedConnect program means being in a perpetual state of financial instability. I will never be able to buy a house because I will never have enough savings for a down payment without being terminated from the program. I will always have to take out a loan, a car loan, and be in debt because putting anything over $10,000 on a reliable car will result in me being terminated from MedConnect. I will never have a fully funded emergency fund because it will result in the termination of MedConnect coverage. In closing, I ask that you vote for the act eliminating income and asset limits for the MedConnect program for persons with disabilities. If passed, this act will allow me to pull myself up out of this draining financial instability and redirect my energy to living a healthy life for many more decades to come. Thank you for your time and consideration.
Diane, thank you. And thank you for staying the path and not giving up. We're glad to have you here. Appreciate that. Any comments, questions? Thank you so much. Truly appreciate you being here.
Thank you.
Next is Sarah LeMaster.
Hello, good afternoon, distinguished chairs and leadership of the Human Services Committee. This is a hard act to follow. It was very powerful testimony. My name is Sarah LeMaster, and I'm the Manager of Government Relations and Public Policy for the Community Health Center Association of Connecticut. My colleagues before me have testified on Senate Bill 191, an act concerning federally qualified health center payments and the provision of non-emergency dental services at such health centers. The Community Health Center Association is our primary care association in Connecticut, which supports the work of 16 of Connecticut's health centers. We collectively serve over 380,000 residents every year and specialize in providing care for traditionally underserved communities. Throughout the COVID-19 pandemic, our health centers have worked diligently to protect our communities and support our public health infrastructure. They've provided care to tests to over 930,000 people and fully vaccinated over 386,000 residents since August of 2020. This bill will modernize and update our statutes to reflect what is current practice in many of our health centers. However, we have concerns about the intent. We support the intent of this bill. However, we do have concerns about lines 14 to 19. They seem overly broad, and we'd like to request that the committee get clarification on whether this portion of the bill would require that DSS switch to an all-inclusive encounter rate, essentially combining medical, dental, and behavioral health services under one rate, or if we would continue to operate with separate medical, dental, and behavioral health rates. CHCAC strongly opposes any effort to bring all patient services together under one rate, as this would dramatically impact health centers' ability to continuously operate and offer services. With our written testimony, we've submitted a proposed amendment to this bill. Our health centers have been operating for over 20 years under a rate-setting system that does not reflect the cost of delivering care to the communities that they serve. They have expanded the number of sites where people can get care. hired additional providers to meet the demand for services, and adjusted the ways that they deliver care to respond to the needs of health center patients. In addition to providing medical, dental, and behavioral health services, our health centers also offer programs to support chronic disease management, help patients access low-cost prescription drugs through the federal 340B program, and enroll thousands of patients every year in health insurance. They adapt their programs to support the needs of our communities. A majority of our health center patients identify as people of color, and over half of health center patients receive Medicaid benefits. We serve a majority of Connecticut's uninsured population, offer healthcare to farm workers, and operate homeless shelters serving over 15,000 people every year who experience homelessness. As I said earlier, we have adapted our model of care in response to the needs of the communities that we serve. We submit annual reports to DSS that reflect the costs associated with caring for Husky recipients. We also submit an annual report to the Federal Health Resources and Services Administration that reflect the overall cost of administering care to all patients. These reports are public information and reflect that the cost of providing care to the populations that are served have been steadily increasing every year. However, the Department of Social Services has not adjusted reimbursement rates to reflect these differences in the cost of care. Thank you very much for giving me the opportunity to testify today, and I'm happy to take any questions.
Thank you, Sarah. It's good to see you.
It's wonderful to see you, Senator Moore.
We miss you.
I miss you too.
You're in a good place though, so they're lucky to have you. I don't see any questions or comments. So I just want to thank you for your testimony.
Thank you very much.
And the work that you do.
Absolutely. Thank you for all that you do. Have a great day.
You too. Is there anyone else who might be on who wanted to have an opportunity and didn't have an opportunity to give testimony? I don't see anyone. All right. Seeing no further testimony, I want to thank everybody who was able to be here for whatever part of the day you were able to. I know how busy we get during the day. I think Hughes has a twin, so I don't know about that. She's every place. She's every place. Representative Abercrombie, would you like to say anything?
I just want to thank everybody for taking the time to come out and testify. You know, it's really important when we hear from the public and the boots in the ground about what's really going on. So don't think that we don't appreciate you taking the time to testify, and I hope everyone has a great day.
Thank you. Thank you. I think you're all very important, a part of this big puzzle as we try to put things together. So I appreciate everybody. Have a great day for the rest of the day. Sun's out. Enjoy. Take care.